It's 1 o'clock. Let's come back from the lunch break, please. Mr. Maxwell, do you have questions of Mr. Morgan?
Good afternoon, everybody. This is Mr. Maxwell. Your Honor, I have no questions. Thank you.
Thank you very much. I don't know if Ms. Nanasi is on the platform, but I'll ask Ms. Nanasi, do you have questions? Mr. Moore from State Land Office, do you have questions?
Good afternoon, Madam Hearing Examiner. I do have a few questions for Mr. Morgan.
Great.
Good afternoon, Mr. Morgan. My name is Richard Moore. I represent the Commissioner of Public Lands and the New Mexico State Land Office. Thank you for your testimony so far today. I just have a few clarifying questions. To begin, Mr. Suazo had a few questions for you about the definition of operator in certain OCD regulations, and I'll share my screen here so we can discuss that. Can everyone see my screen now?
Yes.
So as you discussed with Mr. Suazo, the definition under 1915-2-7 of an operator means a person who duly authorized manages a leases development or a producing properties operation, or who manages a facilities operation. And do you think it is more appropriate to define a lessee as the person or entity who's authorized to develop an oil and gas lease?
In what context?
In the context of the, I guess specifically, I'm asking in relation to the State Land Office. The State Land Office issues oil and gas leases to develop oil and gas development, to develop oil and gas on state trust land, and in I guess with that context in mind, would it be more appropriate to define an operator as the person or entity who's duly authorized by the Oil Conservation Division to conduct drilling and operate an oil and gas well, and define a lessee as the person or entity authorized to develop an oil and gas lease?
I see. In certain contexts, I could see the wisdom of making that distinction.
Okay. And I also had a few questions regarding your testimony concerning the changes to 1915-9-8 and 1915-9-9. Specifically on page 41 of your rebuttal testimony, you mentioned that in certain portions of those proposed changes, the words officer, director, or partner was replaced by authorized official to accommodate a broader range of company structures and position titles, while still ensuring that the operator can be held accountable for the certification. Is that correct?
That is correct.
Are limited liability companies and the members or managers of limited liability companies some of those company structures or position titles that would be better accommodated by the use of authorized official?
Yes, if that's the way a particular operator were organized.
Okay, and so would it be fair to say that officer, director, or partner on its own is not sufficient to accommodate an operator that is set up as a limited liability company and managed by a manager and members?
I can't speak to that specifically, but I can say that the newly proposed language of authorized official is intended to provide that greater flexibility to encompass that sort of an entity.
Okay. And so then I have a question about subsection E of the proposed changes to, this is 1915-9-8, and subsection E, which reads, an operator, and this is applicant's exhibit 72D, page 2. An operator shall certify compliance annually of its current and past officers, directors, and partners, and its current and past ownership interest in other operators consistent with the amended regulations. Would the use of only officers, directors, and partners in this subsection not afford that flexibility to ensure that limited liability companies and their managers and members are subject to the disclosure obligations being added and the annual certification of the compliance with those disclosure requirements?
Yeah, I mean that's the current language in the regulation. We did not specifically substitute the new term authorized official for that, but I don't think that was intended specifically to exclude that provision or those entities.
Would it be clearer that that limited liability companies and their members and managers are required to certify compliance annually if language such as managers and members is added to officers, directors, and partners in that subsection?
I do think that would accomplish that goal.
And I believe that is those are all the questions that I have. Thank you, Mr. Morgan.
Thank you.
Thank you, Mr. Moore. Mr. Tremaine, do you have questions of Mr. Morgan?
Thank you, Madam Hearing Officer. Michael Hall on behalf of OCD. I just have a couple of questions, really to clarify a couple of matters. If either way. And I apologize in advance. I'm still learning the screen sharing.
I'm gonna try to screen share, Madam Hearing Officer, for him, if that's all right.
Yes, thank you.
Right. But the LFC is 4, and then also the thing items. Either one's.
The problem,
I haven't pulled it.
the problem is this,
Oh,
it blocks me.
oh. Here, there we go. Go to page 2, please. Good afternoon, Mr. Morgan. Michael Hall. You were asked quite a bit about the LFC report, and I just kind of wanted to maybe look at it a little more comprehensively than you were asked to earlier. We agreed that the LFC made recommendations that the legislature should take certain actions, I believe came about in your cross, correct?
We covered that, yes.
Looking here at page 2, can you see that?
Yes.
Okay. Are there other recommendations that the LFC made?
Yes, beyond the recommendations to the legislature, there are recommendations to the Energy, Minerals, and Natural Resources Department to promulgate rules.
And in your opinion, is that what we're doing here today and the next couple of weeks with regard to this rulemaking?
That is my understanding, yes.
And just to be clear, if we go on down a little bit, continuing on to page 3, there's a lot of advice that the LFC gives with regard to what MNERD should do, correct? Energy, Minerals, and Natural Resources Department.
Yes.
Promulgating rules. And if we go to page 23, no, you're good. Additionally, there are recommendations to the legislature and Energy, Minerals, and Natural Resources Department, correct?
Yes,
And just for clarity, on page 37, that also occurs there. So just to kind of tie a bow on it, it's recommendations about rulemaking and statutory enactment, correct?
that is correct. Yes.
Now, I would like to just focus a little more on 7214. Do you have that? The thing, Adam? Okay, that's fine. Do you recall discussion of that statute on your the one with the purple and green and yellow?
It would be fair to say I recall that. Yes.
Fair enough. I won't belabor, but I did want to if you could go down just a little more, Jesse, whenever you get it. I wanted to look a little more holistically, if we could, at that statute, and in particular that subpart A. If we look past the purple, what does that next sentence say, if you wouldn't mind? Sorry to ask you to read, but
That's okay. It says, in establishing categories of financial assurance, the Oil Conservation Division shall consider the depth of the well involved, the length of time since the well was produced, the cost of plugging similar wells, and such other factors as the Oil Conservation Division deems relevant.
and how does that part of the statute, how does that affect, or how has that played into your analysis?
Yeah, I think that language taken together with the language highlighted in yellow makes very clear that the legislature's intent was that there be categories beyond the 3 enumerated categories highlighted in green, blue, and purple in this exhibit.
Pass the witness. Thank you, sir.
Thank you.
Thank you very much. Ms. O'Grady, do you have redirect?
I do. Thank you. Mr. Morgan, have you reviewed NMOGA and IPAM's motion to dismiss and applicant's response?
I have, yes.
I'm going to pull up NMOGA and IPAM's reply in support of their motion to dismiss, if I might share my screen.
Madam Hearing Officer, I object as that's beyond the scope of what the witness was asked about on cross.
Ms. O'Grady?
We would like to present it to clarify that IPAM and NMOGA proposed the language that they were raising in their cross-examination earlier. Mr. Suazo asked about it.
Right. I
Well,
remember that.
And be that as it may, I feel like the motion to dismiss needs to be dealt with on its own when the commission decides it's time to address that particular issue.
Yeah, I'm not sure if this is helpful here.
Okay, thank you, Madam Hearing Officer.
Do you have other redirect?
I do not.
Okay,
Thanks.
thank you. Great. Let's see, Commissioner Ampoma?
Thank you, Mr. Morgan, for your testimony. I do have probably very short questions for you today. I'm looking at your slide number 6 in your direct. And it's titled D, Marginal Wells and Inactive Wells. Let me know if I can proceed with my question.
Yes, I have.
Okay, thank you.
Yes, I have my slides up. Thank you.
Okay. Can you explain to the commission, based on the cross, it sounds like you said you are expecting surety bond. Can you explain to the commission how these surety bonds are set up based on your knowledge?
So a surety bond is one of several options an operator would have to satisfy the financial assurance requirement. the way a surety bond operates is it's a three-party contract between the operator, OCD, and the surety provider. The operator pays certain fees to the surety, and in exchange, the surety promises to or commits to OCD to pay out the face value of the bond in the event of forfeiture. And the surety sets, again, those fees and conditions for the operator. And effectively, what this does is it shifts the risk of default from OCD to the surety bond provider.
Thank you for the information. So I want to focus on number one, where we do have the 15,000 bond per well for each marginal well prior to, okay, that is prior to transfer. So I'll pass on that one. But on number two, so beginning January 1, 2028, an operator shall provide a well plug-in financial assurance for each marginal well. Each operator with a marginal well or wells shall annually review the number of marginal wells registered to the operator and shall update the one well plug-in financial assurance by May 1 of each year. So my question to you is that how does this correlate to the blanket bonding provision that was provided in the statute?
So this would be creating a new category that would be in addition to the category that provides for that blanket bond. And so under this approach, these marginal wells would be subject to this new category and would no longer be able to access that blanket bonding.
So number three, so you cited 15%. So I want to know how did the applicant come up with the 15%?
I believe that was addressed in the testimony of Mr. Purvis yesterday. He had a number of exhibits on the topic where he identified, the various sort of change points in looking at the current statistics for operators and calculating how many wells and operators and how much production fall under that new category.
So let's go to slide number 7. And I'll be very brief here. So in number 7, slide number 7E, we're talking about the inactive wells and then wells in approved and expired temporary abandoned status. So number 1, we're saying that a one well plug-in financial assurance in the amount of $150,000 per well. And then also, so let's focus on that one for a moment. As an engineer, I'm thinking about how wells are plugged. So, there has been a lot of discussion about the statute and some requirements that needs to go into setting that bond. So I just want to go to that statute for a moment. So that would be, I think slide number 4 or something like that. But that would be 70-2-14 requirements for financial assurance. And as an engineer, I want to really look at the numbers. So I want to ask you, it's saying that in establishing categories of financial assurance, the Oil Conservation Division shall consider the depth of the well involved. I want to know, did your analysis coming up with the $150,000 consider the depth involved in a well?
To the extent that the variations in cost related to the depth of the well inform what OCD's average plugging cost has been, yes.
So is it your testimony that the depth of the well was involved in the $150,000 category, establishment of that bond amount?
Yes, because costs related to the depth of the well inform OCD's actual plugging costs.
So, sir, if the depth of the well was involved in your estimation, explain to the commission how a full-down core, which is 1,500 feet, should have the same bond amount for, let's say, a formation which is 8,000 feet.
As Mr. Purvis testified yesterday, and I agree with all of his testimony, although depth of the well is a factor impacting the cost of plugging a well, it's not the primary or driving factor, and that other elements, including specifically the condition of the well, the amount of corrosion, and things like access issues to the well tend to contribute much more significantly to the final cost of plugging the well.
So have you seen a quote for well plugging before?
A quote?
Yeah.
Yes.
So what are the elements that goes into that quote, if you can tell the commission?
They primarily look at the age of the well, the condition of the well, and the ability to get a plugging rig to the site of the well.
So they do not look at the depth to look at the number of plugs that they need to use that to plug the well?
That's a factor, but again, it does not tend to be the determinative or driving factor in that cost.
And they do not consider the depth of the well to look at the materials such as the cement that needs to be utilized to plug the well?
Again, that's incorporated in the actual costs, the invoices that OCD received that inform the calculation of the average cost to OCD to plug the wells.
Now, let's focus a little bit on the OCD cost of plugging the well that the applicant is basing on that to establish $150,000 across board. Are you saying that any inactive well is classified as an orphan well?
Any inactive well? No. As I understand it, although as has been clarified in this proceeding, New Mexico does not currently have a statutory or regulatory definition for orphan well. The definition that OCD uses and that the LFC report uses is for not just inactive wells, but for wells where OCD has acquired plugging authority, either through a settlement or an order.
So is a marginal well the same as an orphan well?
Absolutely not.
So if you look at the statute, they talk about the time, the length of the time since the well was produced, and then the cost of the plugging similar wells of such factors, and then let's say in such factors as Oil Conservation Division seems relevant. So based on your testimony, you see that there are different categories of wells that at least we're going back and forth on. Do you agree that there are different categories of wells?
I do, yes.
And each different category of wells has its own more or less approach and then the cost that will be needed to plug those particular type of wells.
There are differences in the categories that could affect the plugging costs, but most of those get rounded out through looking at the average cost that OCD encounters. And given the backlog of orphan well plugging, by the time OCD gets to plug some wells, there may be a significant gap in time between when that well was last produced and when the OCD-led plugging occurs.
So let me ask you, why is it that, I think the applicant, the MOGA, and all parties involved, I don't think anybody opposes the fact that companies should put the right bond, to plug the well. So then why isn't the applicant proposing that the operator has to put a bond that is equal to the cost to plug the well instead of putting a blanket 150,000?
Because by definition, by the time OCD is expending funds to plug the well, that well has become OCD's responsibility. And so I don't disagree that in many cases, when an operator plugs its own well, the cost would be different than what the cost is to OCD. But the purpose of the financial assurance is not to provide funds to the operator. It's to provide funds to OCD for that subset of wells that have been orphaned and have become the responsibility of OCD. And the $163,000 figure from which the $150,000 figure is based is OCD's actual costs.
Yeah, the OCD actual cost. And my colleague yesterday went back and forth with Mr. Purvis on this, that some of these operators do more or less, they do take care of their wells.
Without question, yes.
So if they do take care of their wells, and I feel like we need to distinguish between prudent operators and then operators that are bad actors. And it sounds to me that the current rule that is in front of the commission does not really clearly define those. Do you agree with me on that, or probably not?
There isn't anything in the proposed rule that differentiates there. I do think it's worth noting that when an operator is required to provide the financial assurance, so let's say it's a one well operation, they provide the $150,000 financial assurance. They're not paying $150,000 out of pocket. They're securing a bond. And to get that bond, they do have to pay an annual premium and maybe put up collateral. The sureties absolutely draw a distinction between prudent operators and other operators in setting the amount of that annual premium and the collateral requirements. If an operator has a demonstrated history of regularly plugging its wells, maintaining operating capital sufficient to plug wells, then a surety will provide them with the financial assurance at very favorable terms because the risk to the surety from that operator is extremely low. On the other hand, an operator who has a history of noncompliance, has wells that are currently inactive and unplugged, the surety is going to require more annual premiums and set higher collateral requirements for that operator. So it's not in the rule, but it's inherent in the system of financial assurances that prudent operators would have much more favorable terms than irresponsible operators.
So let's go to slide number 9 of your direct, and I'm looking at the number 2. So a blanket plug-in financial assurance equal to the annual average of $150,000 per well, covering all wells. Do you believe this is a blanket provision?
It's a blanket provision in that it's going to be one financial assurance to cover the full set of wells that fall within that category.
And do you believe that the use of the blanket in this provision is appropriate? You know, are we not contradicting what the statute says?
I believe this is consistent with the requirement of the statute. The statute, the only provision that directly applies here is that it sets the minimum amount of $50,000 for the blanket financial assurance available for this category of wells. And by definition, this E1 is above that level and so meets that statutory requirement.
So, sir, my last question to you, are you familiar with the EPA process of assessing bonds?
In what context?
So let me use EPA Region 9 as an example. So EPA Region 9, if you want to drill a well on the Navajo Nation, for instance, as part of your financial assurance, you have to go out there and get about 3 quotes to plug the well. And then EPA is going to review that and then decide which of the quotes that they want. And even they can adjust it any way they want. And then use that as an instrument to satisfy the financial bond. Why do you believe that that analysis doesn't necessarily work for New Mexico?
That's an extremely labor-intensive process, and I'm not sure OCD's current level of staffing could sustain that level of analysis. It would create an enormous backlog that would prevent the issuance of bonds to operators or permits to operators.
Okay, I'm going to ask the OCD about that, but thank you so much for your time. I appreciate that.
Very
Thank you.
good.
Thank you. Commissioner Bloom?
Good afternoon, Mr. Morgan.
Good afternoon.
Just a few questions. Most of mine were asked and answered along the way. Just want to turn back to the statute, the rainbow paragraph we're looking at one last time, 70-2-14. You, the applicants, are creating a new bond called a blanket bond, correct? Or rather, you are allowing operators to put on one bond or one document all of their required $150,000 single well bonds, and it's referred to as a blanket bond?
That is correct, yes.
Okay. And here in statute at 70-2-14, we have in the statute something else that's called a blanket bond, correct?
There are two blanket bonds referred to in the statute.
Yeah. Perhaps we could give the I don't know if it's newly created, but I think in a sense your idea for something that would be more convenient for people. Perhaps we give that a different name so that it's not duplicative with the statute or potentially confusing.
Commissioner Bloom, I'm sorry if I might be able to help here. I believe the words used in the proposed amendments is single instrument, not blanket bond.
Still has blanket in there, so it's not confusing.
In the testimony or in the proposed actual rule amendment?
In the proposed actual rule amendment.
All right. I'm sorry, I remembered single instrument.
In the rule amendment?
There's two, I think there's two different provisions here. There's subsection E, which refers to the, which modifies the current provision of the blanket plugging financial assurance. And then there's also provision F, which allows operators to provide a single financial instrument to satisfy all of their bonding requirements. Those are separate provisions.
Thank you.
To my fellow commissioners, I'm just looking ahead. If and when we craft a final rule here, perhaps we could refer to this new one as something like a multi-well bond, just to avoid this confusion with the statute. All right, thank you, Mr. Morgan. Also, I think in 70-2-14, we've had some discussion here and more generally about the intention of the legislature. I think you've received some questions on that.
I have, yes.
In literature, there's something called the intentional fallacy, where it's no longer typical to try to discern the intentions of the creators or something, or the writers of something, based on the final output. We don't know why everyone in the legislature voted for this. We don't know why certain chairs allow things to pass or don't pass. Sometimes their stated reasons are different than the actual reasons. If you've spent any time at the Roundhouse in New Mexico, you've certainly seen this. Would you agree that the governor also has to sign legislation to make it law?
That's my understanding.
Correct. And I don't think we've had any conversation about what her intent might have been when she signed this, or how she interpreted the definitions related to wells. Is there any language in 70-2-14 which explicitly limits the creation of other single well bonds?
As discussed earlier, I think the limitations are that any additional category that might encompass that would have to go through notice and hearing. And then there's the language I discussed with Mr. Hall that specifies, specific factors that the commission should take into consideration in setting those additional categories. But outside of that, I'm not aware of any limitations.
Okay, thank you. Just wanted to, I think lastly, turn to the discussion of the W&T case that came up in Mr. Emmerich's rebuttal. I think this was covered, but I did want to underscore it, that the W&T case, is that not for offshore drilling?
It is specific to offshore drilling, yes.
So are we talking apples and oranges here, in your opinion?
I think it would be unlikely that the same factors at issue there would come into play in New Mexico. The purpose of my testimony was just to provide broader context to the statements that have been made within that litigation. But yes, I think the probably more important point is the distinction between offshore drilling and the sort of drilling we see in New Mexico.
And perhaps the absolute difference in scale of those two of our proposed financial assurance here in New Mexico versus this offshore bond, which appeared to be something of the order of $55 million.
Yes, I mean, I think the operator's overall surety requirements there are in the hundreds of millions of dollars.
Yeah. I look forward to hearing from Mr. Emmerich a little bit later, but he also mentioned that he's heard that the collateralization or the provision of collateral might be required if this proposal were to be enacted. Do you have anything you'd like to say related to potential for a required provision of collateral?
Yeah, I mean, although I absolutely agree with your statement that the factors in play in the offshore realm are different, I do think the statement that I provided in my rebuttal yesterday from the surety speaks directly to your question. So if I can quote that again, I think it addresses your question. The surety said, in responding to the suggestion that the surety would automatically, in response to a change in financial assurance rulemaking, would increase the collateral requirements, the response of the surety was, quote, "It would make no sense and be economically irrational for the sureties to take any action that would threaten W&T's financial viability such that it could not perform its obligations, because the sureties would then be on the hook for those obligations. W&T does not explain why the sureties would be motivated to force potential customers out of the market. It would be economically irrational for the sureties to require impossible collateral repayments, cripple their customers, and demand collateral terms that would effectively prevent smaller oil and gas companies from obtaining government-mandated bonding." I see no reason why that same logic wouldn't apply in the case of the New Mexico rulemaking.
No further questions. Thank you, Mr. Morgan.
Thank you.
Thank you, Commissioner Bloom. Chair Chang?
No questions at this time. Thank you.
All right. Thank you very much, Mr. Morgan.
Thank you.
Madam Hearing Officer, can take up one matter before the next witness is called?
Yes, absolutely.
Thank you. Not being critical, but I think Mr. Morgan was on for about an hour and 45 minutes of direct, redirect, and rebuttal, which was longer than was allotted. And as long as the same courtesy is extended, not going to object. But if that's not going to be extended, then I want to make sure that we stay within the allotted period of time we discussed for all three, which would be an hour and a half.
Madam Hearing Officer, there is no time limit for rebuttal, and he did stay within his time limits for direct and rebuttal.
I guess I thought you did. I do make notes of the exact minute when things begin and end, and I thought it was an hour on direct, half hour on rebuttal, and about 15 minutes on Sir
I,
rebuttal?
I agree that's what it was, but we discussed earlier in the hearing, and again, I'm not trying to be contentious. I just want to make sure the rules are applied, there's additional time for Sir rebuttal in addition to the times we've already designated. So
Yes.
Yeah.
Thank you very much.
thank you.
Let's see. Are we going to Mr. Peltz? Okay.
We go ahead and, could I get a 5-minute recess while they're setting up anyway?
Oh, yes, let's take 5. Okay, let's come back from the break, please. Does Mr. Peltz have screen sharing authority? Oh, okay, thank you. All right, the hydrated Mr. Peltz is in the witness seat there. Mr. Peltz, would you state and spell your first and last name?
Yes, my name.
Oops.
My name is Adam Peltz. ADAM is the first name, and the last name Peltz is PELTZ.
Do you swear or affirm to tell the truth?
Yes.
Thank you. Go ahead, Mr. Tisdale.
It'll take one moment as Ms. Fox pulls up the PowerPoint.
There's no slide for a little bit if you want to get going.
Okay. Please state your name for the record.
My name is Adam Peltz.
And what is your current employment?
I am a director and senior attorney at the Environmental Defense Fund.
What is your educational background?
I have a Bachelor of Arts in Political Science and International Studies from the University of Chicago and a master's degree in International Relations and a law degree from Boston University.
Would you describe your work background with particular attention to your experience working on financial assurance for oil and gas operations and the risks of inactive and orphaned wells?
Yes. Since 2011, I have worked nationally on local environmental impacts of oil and gas development. Since 2020 in particular, I have focused heavily on orphaned and abandoned well issues. Working closely with Senators Lujan of New Mexico and Kramer of North Dakota, the Interstate Oil and Gas Compact Commission, and the Independent Petroleum Association of America, I helped conceive and advocate for passage of the Revive Economic Growth and Reclaim Orphan Wells Act, or REGROW Act, which provided $4.7 billion to states, tribes, and federal land management agencies to plug and remediate orphaned and abandoned wells across the U.S. The legislation includes incentives for states to reduce future orphan well burden through legislation or rulemakings like this one that address financial assurance, idle well management, and well transfer. The legislation was adopted as part of the 2021 Infrastructure Investment and Jobs Act, aka the Bipartisan Infrastructure Law. New Mexico has so far received $55.5 million from that funding and is eligible to receive another $111.8 million. I'm currently engaged in legislative or rulemaking activities on financial assurance, idle well management, and well transfer in Louisiana, Texas, Oklahoma, and Utah, in addition to New Mexico. I serve on a National Academy of Science consensus study on orphan well plugging. And during my time as the chair of IOGCC's Energy Resources, Research, and Technology Committee, I worked with the Society of Petroleum Engineers on a webinar series about issues relevant to state oil and gas regulators, including sessions on orphan wells. EDF's economics team and I have produced analyses of the likely fate of well populations in 6 states, including New Mexico, delineating orphan risk, transfer risk, and low-risk wells through 2050, and idle well historical analyses and job creation potential from plugging and remediation work in Louisiana, Texas, and New Mexico. I am co-author on several peer-reviewed papers on various aspects of orphan wells.
Thank you. What work have you done specifically in New Mexico?
Aside from assisting the applicants as an expert in this rulemaking since the spring of 2024, I participated in the lengthy and complex stakeholder negotiation process initiated by MNERD in the fall of 2023 to reform the Oil and Gas Act, and I co-led the financial assurance subgroup. I was also asked by the New Mexico Legislative Finance Committee to provide a presentation on the orphan well problem in New Mexico in May of this year. The result of the LFC effort is its report on orphan wells issued on June 24th, which is applicant's Exhibit 4.
Did you provide direct testimony in this case?
Yes, my direct testimony is applicant's Exhibit 57.
Do you have any corrections to that testimony?
Yes, on page 22, line 20, there is a reference to the Energy Information Administration's short-term energy outlook. In addition to the STIO, there should also be a reference to EIA's annual energy outlook. Also, there's a reference to the GOTEC database on page 51 that should cite NM Tech rather than UNM. Sorry, Commissioner.
With that correction, is your direct testimony accurate to the best of your knowledge, and do you adopt it?
Yes and yes.
Is applicant's Exhibit 56 an accurate copy of your resume?
Yes.
Right. Mr. Peltz, when you refer to orphan wells, what do you mean?
Oh, one more slide. Thank you. Generally, orphan wells are non-producing, unplugged oil and gas wells with no solvent responsible party able to pay for plugging and remediation costs, and thus cleanup responsibility falls to the state. New Mexico does not currently have a regulatory definition for orphan wells. The LFC report recommends amending the Oil and Gas Act to define orphan wells consistent with its common use in industry and clarifying that orphan wells are wells for which the state has pursued and received plugging authority.
Can you describe the orphan well problem facing New Mexico?
Yes. When a well reaches the end of its life, it needs to be properly sealed to prevent negative impacts on the surrounding environment and human health. Unplugged wells can have a host of disastrous consequences. They emit methane, a powerful greenhouse gas. They contaminate groundwater with toxic chemicals. Then they negatively impact property values. When wells are unplugged, no longer actively producing, and have no solvent operator responsible for them, they become orphan wells. New Mexico, along with many states, faces a growing population of orphan wells that threaten the health of communities and the environment and pose a massive economic burden on the state. Thus, reforming New Mexico's regulations on this topic is necessary. The LFC agrees. LFC's goal is to assess the scope of the problem with a focus on environmental, health, and safety impacts of orphan wells, and given the scope of the problem, evaluate the adequacy of the state's regulatory framework to address current orphaned wells and prevent future orphaning. LFC estimated the state's future liability from orphan wells. The scope of the liability is dramatic and underscores the need for the changes we are proposing. LFC estimates the future liability to the state ranges from $700 million to $1.6 billion. For a state whose budget just recently broke $10 billion, this is unsustainable and reforms are needed now. Next slide.
We'll get there.
It'll get there. Okay. LFC makes several recommendations for MNERD. Its regulatory recommendations accord with our proposals, which preceded the LFC's report. First, the LFC recognizes the importance of defining low-producing wells because they are at high risk of orphaning and require additional regulatory oversight. We agree, and this is reflected in our proposal for additional regulatory controls for a category of wells we term marginal wells. Second, given that the high orphaning risk from low-producing wells, LFC proposed operators secure individual financial assurance instead of blanket bonds. We also agree, and this is reflected in our proposal for one well financial assurance for marginal wells. This category was initially proposed by OCD staff based on their field experience. Third, LFC found that regulatory oversight is needed for well transfers to reduce operators from escaping liability. Applicants also proposed changes to protect against high-risk transfers. One of the state's most important legislative committees have recognized that that orphan wells pose a great threat to New Mexico. This rulemaking is a critically important step to protecting New Mexico's people, climate, and environment from orphan wells.
Can you describe national trends in the regulation of oil and gas that influence the timely plugging of wells?
Yes. The first plugging rules came into being in Texas and Oklahoma in the late 1800s and early 1900s, several decades after the first oil and gas wells were drilled in New Mexico. Historically, most states did not assiduously enforce plugging requirements, and many still do not, though every oil and gas state has long required operators to plug their non-producing wells. The IOGCC, the Interstate Oil and Gas Compact Commission, has tracked this since the early 1990s. In 2020, as conversations about what was to become the Regrow Act began, IOGCC tracked over 56,000 documented orphan wells in 30 states. Once states saw that the Regrow Act was likely to pass, they scrambled to document their orphan wells because their share of the $4.7 billion was predicated in part on their documented orphan well population. By the time states expressed an intent to apply for formula grants to the Department of Interior, that count was up to 125,000. In the latest IOGCC report, the count is 141,000, although estimates for undocumented orphan wells range up to 800,000 in the latest IOGCC report, and I suspect they're quite a bit more than that. Recently, state legislative and rulemaking activity has rapidly increased in an effort to bend the curve on the orphan wells epidemic and protect taxpayers, public health and safety, local property values, as well as to ensure the geologic integrity of the surrounding area. This is partially due to unprecedented public scrutiny on the issue after the passage of the Regrow Act. Now, the problem of orphan wells is in local, state, and national news on a near daily basis. The issue resonates with the public, which understands the basic imperative to require operators to clean up after themselves, and who do not look kindly on how the richest industry in the world too frequently ignores its closure and remediation obligations. I think we can go one more than this. There we go. Okay. Generally, there is substantial public support, including bipartisan support, for holding oil and gas companies responsible for cleanup instead of taxpayers, as shown by EDF and other polling. And this is polling that EDF did in the last 2 years or so. EDF polling is Applicants Exhibit 58. In addition to the simple question of whether operators should plug their non-productive wells, can we go to the next one? Okay. We also asked if respondents would support such requirements even if they force small operators out of business, which is certainly not our intent by any stretch of the imagination. It is nevertheless striking how strongly support remains among New Mexicans across various demographics. In my direct testimony, I detail other states' initiatives. In a nutshell, the Texas industry, led by the Texas Oil and Gas Association, developed legislation that became law in June 2025 to limit the length of time wells could remain idle, which has prompted several rulemakings, which are scheduled to be wrapped up by December 31st, 2026, as well as a required annual report on the fate and trajectory of the idle well population. In Oklahoma this year, the legislature set a time limit on well idling and raised financial assurance amounts, and also eliminated the ability to provide financial assurance via financial statements, i.e. self-bonding. In Louisiana, the rulemaking in 2023 set limits on well idling, reduced the discretion of the regulatory agency to indefinitely renew temporary abandonment status, and instituted idle well fees that increase over time to incentivize operators to plug their wells. In Utah, after a legislative audit found that the state's approach to financial assurance left taxpayers with unacceptable risk, the Utah regulatory agency began a stakeholder process to modernize Utah's bonding rules with a risk-based approach. The regulatory agency supports a policy that blanket bonds are a privilege and not a right, and should only be available to solvent operators as proxied by fleet-wide production and their percentage of idle and sub-marginal wells in their fleet, which in Utah is defined as less than 1 BOE per day of production. In addition, operators must provide single well bonds for their idle and sub-marginal wells. And operators who do not qualify for blanket bonds must obtain single well bonds for all their wells. This matter is now before the Utah Board of Oil, Gas, and Mining, which is collecting analytics to determine how to proceed. And they're going to have a hearing on this on December 3rd, in case anyone wants to go to Salt Lake City. Since 2020, California and Colorado both overhauled their approaches to financial assurance, idle well management, and well transfer. California requires full cost financial assurance for marginal wells on transfer or after workovers. Colorado has created a multi-tier system along with a new annual orphan well fee designed to generate around $10 million a year to cover future orphan wells. Other states have programs to address orphan and idle wells as well. Wyoming adopted a policy of essentially full cost single well per foot financial assurance for all idle wells. North Dakota limits blanket bonds to 7 idle wells. Alabama has almost no orphan wells because of a long-standing state policy to go after all scofflaw operators, whether it generates revenue for the state or not. And finally, Arkansas pioneered the concept of full cost financial assurance for marginal wells on transfer in 2018. The point here is this: oil and gas producing states are coming to grips with the severity of the orphan well problem facing them and are taking regulatory action to address and prevent orphan wells.
In your opinion, is the current regulatory framework in New Mexico sufficient to ensure the adequate plugging of wells?
No, and I am in good company. Both the State Land Office and more recently the LFC found that the taxpayer risk from future well orphaning is unacceptable due to insufficient regulatory policy and enforcement. New Mexico has over 63,000 oil and gas wells that will eventually need to be retired. Without adequate regulation, the orphan well problem will only worsen over time. Given the looming liability, LFC finds that the current financial assurance requirements for operators are insufficient. EDF projected expected bonding amounts required under current financial assurance rules based on a snapshot of 2024 production, based on an estimated plugging cost of $163,000 each for OCD to plug the same set of wells. The bonding requirements under current rules are only estimated to cover 1 to 2% of the potential liability, even before environmental remediation is accounted for. This data is shown on Applicant's Exhibit 63.
How was EDF data reflected in your exhibits as developed?
EDF has a superb analytics team that, working with me, developed the data, graphics, and charts for my exhibits. One of our data managers was responsible for collecting the data, which is generally from OCD's databases, GoTech, and Enverus, and generating the exhibits. She worked closely with her manager and a postdoctoral economics fellow, all part of our economics team, to assess and QA the data.
What other considerations factor into the need for increased financial assurance as proposed by applicants?
New Mexico is producing record amounts of oil and gas production. Oil production has increased dramatically since 2010, rising more than tenfold from 66 million barrels in 2010 to 745 million barrels in 2024. A look at the wells responsible for this boom in production reveals these record highs are driven by wells drilled within the past 5 years. Looking at Applicant's Exhibit 59, oil production has risen rapidly since 2015, primarily due to the Permian shale boom. Since 2020, all growth has come from these newer wells, while the share of older well production has shrunk dramatically. Now, the vast majority of production in the state comes from wells spudded in just the past 5 years, meaning the entire large fleet from earlier vintages is rapidly becoming unproductive and thus uneconomic, representing an increasingly large liability with increasingly less revenue to cover those costs. The EIA's latest short-term energy outlook and annual energy outlook forecast production to be relatively flat through 2026, with long-term projections of U.S. production increasing through 2027 and 2028, primarily driven by production from the Permian Basin. followed by leveling off and gradually declining production after 2028. At the same time, the EIA projects lower crude prices over the next few years. Although oil market forecasts and projections have inherent uncertainty, all indications are that there will never be a better time for New Mexico to strengthen its financial assurance regulations of oil and gas wells. While markets remain strong and the industry can afford to invest in taking care of its current inventory and future legacy wells, I don't think we can ignore in good conscience the opportunity to secure legacy cleanup costs during this boom time. While production has boomed among a relatively small set of wells, New Mexico faces a growing population of low-producing and inactive wells. EIA's 2024 annual well distribution report indicates that 54% of the state's producing wells produce less than 15 BOE per day and account for only 2% of the state's oil and gas production. These low-producing wells represent only a small fraction of the state's production and revenue and are most systemically consequential as a growing retirement liability. The state has an opportunity to get ahead of the curve and curtail this growing risk with updated regulations without impact to the overwhelmingly vast majority of production. Similarly, an analysis from Mr. Purvis that we all saw in the last few days shows that outside the Permian Basin, and except for horizontal wells drilled within the Permian, production from most wells and regions in New Mexico is in long-term decline. The majority of the 63,000 wells that will ultimately need to be plugged are low producing, as demonstrated in applicant's Exhibit 32. Indeed, approximately 34,000 wells produce less than 10 BOE per day. A recent analysis by EIA highlighted that nearly all recent and forecasted production growth in the U.S. is coming from horizontal wells in the Wolfcamp Formation within the Permian Basin, while production from vertical wells is in decline. Production from horizontal wells in other tight oil plays is relatively flat and forecast to remain flat. These trends are reflected in the 3 EIA figures that I'm showing you. The Permian is truly something else. To summarize, according to the EIA, more than 60% of New Mexico's unplugged wells produced less than 10 BOE per day in 2024. These wells together produced around 1% of New Mexico's annual oil production and 13% of the state's 2024 gas production, yet present a significant financial risk to the state in terms of plugging costs if these operators go bankrupt. New Mexico is producing more oil right now than most OPEC countries, and there may never be a better time for industry to adequately prepare for its eventual plugging liabilities, and for the state to begin to more effectively hold industry accountable for plugging their own wells.
How do wells in inactive and in approved and expired temporary abandonment status fit into this landscape?
As discussed by Mr. Alexander, there is a growing trend by operators of leaving wells in expired TA status rather than plugging them, as shown by applicant's Exhibit 61. The proposed rules will go a long way towards reversing this trend. The data also show that wells linger for years in approved and expired TA status, and that the longer the well is inactive, the more likely it is to be in expired TA status and out of compliance, as shown by applicant's Exhibit 62. Let's return to applicant's Exhibit 63. An EDF analysis estimated that the total plugging liability to be $3.4 billion across New Mexico's state and private wells, based on a snapshot of 2024 production levels. Under existing rules, the total bonding amount estimated for all operators for this same set of wells is less than $72 million, covering barely more than 2% of the potential $3.4 billion needed to plug these wells. Under the proposed rules, estimated bonding across all operators would increase more than 17-fold to around $1.1 billion, increasing the coverage to roughly 1/3 of the $3.4 billion total plugging liability. This increase falls primarily on risky operators with more than 15% of their wells in marginal or inactive status. And this will incentivize reactivation or closure of these wells to bring operators under this threshold. As illustrated in applicant's exhibit 64, comparing each analyzed operator's projected bonding amounts on the y-axis to projected plugging liability total for the same number of wells on the x-axis indicates that higher risk firms would be subject to financial assurance requirements approaching 100% of the costs to the state to plug, although not remediate, while lower risk firms would be subject to far lower financial assurance requirements compared to expected plugging liability.
Let's turn to applicants' specific proposals establishing new categories for financial assurance, beginning with the marginal well category at 1915-8D1 NMAC. What are the marginal wells and what is the basis for requiring increased single well financial assurance for these wells?
And apologies to everyone, because I think we already know this. Nevertheless, a marginal well, as defined in this application, produces less than 180 days per year and less than 1,000 BOE during a 12-month period, representing a daily production average of 2.7 BOE. In contrast to the federal definition of 15 BOE per day with no days per year requirement. This category of wells comprises a small percentage of New Mexico's wells, representing 3,900 wells, but less than 0.5% of total production in the state, according to Mr. Purvis's data. But they represent a high risk to the state with plugging costs that appear to far exceed present and future potential or revenue potential. For comparison, 9 wells in New Mexico, each individually reported more total production in 2024 than the sum total of production from all marginal wells as we define them combined, as shown by applicant's exhibit 65. The total annual production of all marginal wells as defined, including presumptively no beneficial use wells, is around 760,000 BOE per year. The 9 wells above the line here each produce more than that, each one. The 10 wells below the line each produced over 700,000 BOE in 2024, which is not too shabby. Looking at all active New Mexico wells that produce less than 1,000 BOE per year, their total gross revenue can be estimated at around $26 million in 2024, or less than $1,300 per well on average. In other words, there is a significant number of wells that are active in name only, and certainly not at levels that would also cover the cost to plug, abandon, and remediate the site, which is estimated to average around $249,000. The math doesn't work. Requiring full cost financial assurance for low producing wells was first conceived of by Arkansas in 2018 in the context of transfer and has since been adopted by Colorado and California. The theory behind such a provision is that historically and through today, low producing wells are transferred and sold down the value chain to increasingly poorly capitalized operators until the final bankruptcy-proof operator walks away and leaves the state holding closure responsibility. If a well is not producing enough to pay for its own plugging or financial assurance to cover the eventuality of state plugging, it should probably not be operating, given environmental, climate, and closure cost risks to the state, unless the operator is willing and able to subsidize its operational costs through other revenue sources. Alternatively, to avoid single well financial, operators wishing to avoid single well financial assurance can work over or otherwise recomplete their wells to increase their production and take them out of marginal status. The delay in applicability to 2018 gives operators time to increase production, transfer, or plug their marginal wells if they wish. Applicants propose an implementation period of approximately 2 years until January 1st, 2028, for operators to adjust to the increased financial assurance requirements and immediate application to marginal wells upon transfer because of the heightened risks I've discussed at the point of transfer.
Turning to the new category of financial assurance for operators with 15% or more of their wells in marginal and or inactive status at 1915-89F3 NMAC, what is the basis for this category?
The category of financial assurance aims to address the systemic risk posed by operators with a large portion of their wells in marginal or inactive status, or a combination of both. This proposal, initially proffered by OCD and adopted by applicants, requires operators whose portfolio consists of 15% or more of their wells in marginal or inactive status, or both, to provide full cost financial assurance for all their wells, not just those in marginal or inactive status. As illustrated by applicant's Exhibit 66, such operators tend to have lower than average revenue to potential plugging liability ratios and larger numbers of low or non-producing wells that are likely to need to be plugged sooner. In particular, operators with fewer than 15% of their wells in these high-risk categories have 6 times the average revenue of operators with more than 15% of their wells in these categories. If these operators declare bankruptcy or are otherwise unable to meet their closure obligations, the sudden costs to the state may be very high. One recent example of this dynamic unfolded with Ridgeway Arizona Oil Corporation, a Texas-based subsidiary of a publicly traded private equity-backed company that was unable to meet its plugging responsibility for 299 wells, leading the state to take on $30 million in plugging liability. In a settlement with the state of New Mexico, Ridgeway agreed to a $30,000 per month repayment plan, which would take more than 8 decades to make the state whole if the operator is able to continue to meet its payment obligations over that period. Far from a guaranteed outcome. Ridgeway's percentage of marginal and inactive wells under the proposed definitions was over 90%. This category is patterned after a rule proposal by Utah's Division of Oil, Gas, and Mining, which requires single well financial assurance for all of an operator's wells if more than 25% of their well population is idle or below 1 BOE per day. The more stringent nature of the proposal here reflects OCD's understanding of New Mexico's landscape and operator dynamics, and is supported by assessing the characteristics of operators likely to fall above this threshold, as I will describe. This category creates an incentive for operators either to increase production or transfer or plug their low and non-producing productive wells, all of which is in the public interest, as long as appropriate bonding is required upon the transfer of the well. Applicant's Exhibit 67 shows the distribution of operators by marginal and or inactive well percent, and also shades operators by absolute number of marginal and inactive wells. Those operators with a low marginal and or inactive well percentage, but a high absolute number of such wells are relatively large companies, while those with a high marginal/inactive percentage and a low number of marginal/inactive wells are relatively small. Darker colors further to the right on this plot represent increased risk. Especially concerning is the tall column all the way to the right, indicating that all of each of these operators' wells are marginal or inactive. These operators seem highly likely to orphan their wells in the absence of outside capital. Meaningfully assessing the financial health and associated risk of operators is complex and challenging to classify based on any single metric or regulatory threshold. However, average revenue levels can serve as a proxy to help contextualize an operator's likely ability to meet its expected plugging obligations. As part of analyzing expected bonding amounts and plugging liabilities for a 2024 snapshot, EDF estimated the total revenues generated in 2024 by each modeled company's state, private, and federal lease wells in New Mexico, as shown in applicant's Exhibit 68. These values were then compared to the expected cost for the state to plug each operator's marginal or inactive wells at $163,000 per well. For operators to the left of the line, their total modeled state plugging costs for their state and private marginal and inactive wells exceed their annual revenue. All of those operators are above the 15% threshold. Now, while the 15% threshold does not perfectly split companies on this basis, only a third of the modeled operators exceeding the proposed threshold can meet this criterion of 2024 revenues exceeding estimated plugging liability for risky state and private wells. Now, these are the operators to the left of the line. Meanwhile, nearly all, 98% of those operators with fewer than 15% marginal inactive wells can meet this same criterion, those to the right of the line. This suggests that as a group, the operators below the proposed 15% threshold are significantly more financially resilient relative to the potential financial risk they pose to the state.
Moving to 1915-89E NMAC, providing for inactive wells, including wells in approved and expired TA status. What is the basis for this proposal?
Under the Oil and Gas Act, the Commission shall establish by rule a blanket financial assurance for temporary abandoned status wells at amounts greater than $50,000. And the Commission shall require a one-well financial assurance on any well that has been held in temporary abandonment status for more than 2 years. The legislature, by setting a floor and not a ceiling on bonds for TA wells, have recognized the increased risk to the state that those wells represent. And by requiring a one-well financial assurance for wells that have been in TA status for more than 2 years, the legislature has recognized that the longer a well is in TA status, the greater the risk. While the legislature has recognized the increased risks from wells in approved TA status, the vast majority of wells on OCD's inactive list are either in expired TA status or, in far more cases, are just inactive with no apparent formal status or agreed compliance order. Wells in expired TA status or that are simply inactive are out of compliance with the Commission's rules and therefore are inherently riskier than wells in approved TA status where operators have followed the rules of the road. As discussed by applicant's expert Tom Alexander, approximately 3,200 wells out of 3,700 wells on the inactive well list are out of compliance, totaling 86% of the wells in inactive status, as illustrated by applicant's Exhibit 7. It was probably before. There it is. Okay, great. This data is shown again in applicant's Exhibit 10. It is these wells in approved TA, expired TA, and inactive wells that have never gone into TA status that by all measures are the highest risk since they produce no revenue at all and which should have full cost financial assurance to protect the state. Requiring full cost financial assurance for non-productive wells is increasingly common in major oil and gas states. Wyoming generally requires full cost financial assurance for idle wells. North Dakota limits to 7 the number of idle wells on a blanket bond. Recent legislation in Texas requires rulemakings on idle wells generally, and in particular on idle well transfer, including consideration of financial assurance. Let us also take a look at these inactive wells and their various statuses by years since last production. The preponderance of out-of-compliance wells is clear, and also the overwhelming majority of compliant inactive wells have been inactive for 8 years or less. EDF analyzed a large sample of idled wells in New Mexico in applicant's Exhibit 13. The analysis found that most idled wells, if they are reactivated, do so within 2 years. After 5 years, it is highly unlikely that the well will produce again. The analysis found that for wells that were idled and then later reactivated between 2010 and 2024, over 90% reactivated within 3.5 years. Reactivations dropped off exponentially after only 2 years of inactivity. Looking at all instances of wells in the sample that became inactive for 12 plus months, 13% never returned to activity. Of those that did reactivate, the vast majority did so within 3.5 years, over 90%. For purposes of applicant's proposal, requiring wells to be plugged after 8 years of inactivity, the analysis shows that functionally all of the wells that reactivated, 99.5%, did so within 8 years of last activity. The New Mexico analysis is consistent with previous EDF analysis in Texas and Louisiana that found that after 5 years, the chance of a idle well ever returning to service is under 15%, and that post-idling production is usually only a tiny fraction of total lifetime production. Also, oil prices correlate with deactivations and reactivations of well production as tracked in this analysis. EDF tracked transitions for all New Mexico wells included in GOTEC's county production volumes data, which is compiled from OCD production data, looking for all instances of wells becoming inactive for 12 plus months or returning to producing after such a 12-month pause. Looking at Applicant's Exhibit 69, when those transitions are plotted with the West Texas Intermediate prices over time, price declines in 2016 and 2020 correlate strongly with more wells transitioning to inactivity, the green line. After each of these declines, as prices rose again, reactivations in the yellow line also increased, though fewer total wells reactivated after each price event than the number that deactivated by the low point of the price decline. Given that reduced prices represent a more significant impact for operators of low-producing wells with a higher expected ratio of cost to revenues, the wells that fail to reactivate after a sharp price decline are likely those low-producing wells already at most risk of orphaning.
Let's turn to applicant's proposal to establish presumptions of no beneficial use in 19, 15, 25, 9 NMAC. What is the purpose of this proposal?
Establishing presumptions of no beneficial use was initially proposed by OCD based on staff's field experience. The purpose is to establish a class of nominally active wells whose activity levels are presumptively not economically viable and thus must be plugged. This is designed to facilitate earlier identification of wells posing a risk of becoming orphaned and begin the process of ensuring that their decommissioning is paid for by the operator rather than through public funds. The threshold of 90 barrels in 90 days of production, or a quarter of a BOE per day, represents exceedingly low production. The proposal is intended to identify production and injection wells that, while technically active, are producing or injecting so infrequently and at such low levels that they are not viable wells and may be maintained in nominally active status to avoid the heightened scrutiny of inactive status, as well as the immediate cost of plugging and remediation. Nonetheless, the presumption is because of the potential fact patterns that mitigate against the risk of orphaning. Operators ought to be able to make a showing that, despite their minimal production or injection, there is good reason to keep these wells online. As of July 2025, this level of production represents gross revenue of less than $6,000 for oil wells or less than $2,000 for gas wells. The threshold for this presumption is very conservative.
Applicants propose amendments to 19, 15, 25, 13A NMAC regarding wells in approved temporary abandonment status. What is the purpose of these amendments?
This amendment requires that for a well to be placed in approved temporary abandonment status, the operator must demonstrate that the well will be returned to beneficial use within the period of temporary abandonment. If the well has no future beneficial use, it should be plugged and abandoned. Under current rules, operators don't need to make any showing justifying why they want to put their wells into TA status. That status is intended to postpone plugging liability for inactive wells until market conditions improve, the well is worked over, or some other factors that will make the well economically viable in the future despite lack of production for over a year. The intention of this proposal is to require a showing along these lines to justify the risk the state is taking in allowing the wells to stay open. This risk includes not only the financial burden of plugging and remediating the well, but potential air, water, and land contamination during the pendency of the TA status, hence the requirement for detailed well integrity data, as well as considerations about ultimate resource recovery from the tract and whether the well is being used to hold the lease and is stymieing development of other formations in the area. The information collected in this process will help the OCD plan for well plugging and remediation in case the operator orphans the well during the TA duration.
Applicants also propose changes concerning conditions to extend a well's TA status. What are the proposed changes and the purpose of these amendments?
The proposed amendments require a demonstration from the operator of its plan to return the well to future beneficial use. Currently, New Mexico has no time limitation on how long a well can remain in TA status, only that an application be renewed every 5 years. Wells that are not renewed move into temporary expired TA status. Looking at Applicant's Exhibit 70, New Mexico currently has over 800 wells reported by OCD as being in approved or expired TA status. Based on earliest reported date of TA status, nearly 30% of these wells have been in TA status for over 5 years as of July 3rd, and some evidently for decades. Moreover, as illustrated in Applicant's Exhibit 71, which is the next slide.
We'll get there. Here we go.
Okay, great.
Sometimes it doesn't work.
Okay, so moreover, illustrated in Applicant's Exhibit 71, nearly half of TA wells have been inactive for 5 years or more, and some have been inactive upwards of 30 years. While long-term inactive TA wells are by definition technically not orphaned because an operator of record still exists, there is little chance that such wells will ever be returned to beneficial use. The current structure allowing indefinite TA time essentially operates as an undefined subsidy from the state to the oil and gas industry, whereby operators are allowed to keep wells indefinitely open and avoid the cost to permanently plug and abandon those wells, all while creating significant additional risk that the state and taxpayers will ultimately bear those costs. The impact of the proposed changes is to put an outside limit of 8 years for wells to remain inactive. For the first 13 months of inactivity, operators would not be required to make any special showing. Then, for 5 more years of inactivity, operators must provide a plausible and legitimate reason backed by evidence to enter TA status. Applicant's proposal allows operators to request an extension of TA status for up to 2 additional years. Upon satisfactory explanation for the extension, a showing that the well will not cause health, safety, or environmental problems during the pendency of the extension, and a plan for decommissioning. As discussed, EDF analysis indicates that 99.5% of wells that are deactivated will reactivate in less than 8 years if they are going to reactivate at all. And over 90% will do so within far less time, 3.5 years after the start of inactivity. Thus, for the vast majority of wells, based on New Mexico data, keeping a well inactive for more than 8 years is neither reasonable nor necessary.
This concludes Mr. Peltz's summary of his direct testimony. We will now move to a summary of his rebuttal testimony.
Thank you.
Mr. Peltz, you provided rebuttal testimony in this proceeding, Applicant's Exhibit 82, correct?
Yes, I've made it through almost a liter of water in the direct water. Truly important.
Glad you're staying hydrated. Is it accurate to the best of your knowledge, and do you adopt it?
Yes and yes.
Before we discuss specific testimony, what are the general areas you intend to cover in your summary of rebuttal?
9 general themes popped out to me as I reviewed the rebuttal testimony, which I will cover in this order. And by the way, there's very few slides. So this is mostly just me talking. The first is statutory authority. The second is administrative burden. The third is around risk-based financial assurance. The fourth is impact on small operators. The fifth is impact on marginal well operations. The sixth is the specter of premature plugging. The 7 is reduced capital access and transfer flexibility. 8 is the size of the proposed single well financial assurance. And 9 is the question of whether the proposed language would reduce future orphan well burden in New Mexico. I will also address a few other issues brought up in industry direct testimony, namely the relationship between inactive well integrity and orphan risk, the role of lease retention in operator plugging decisions, and the Colorado experience.
Let's begin with the Commission's and OCD's statutory authority to adopt the applicant's proposed amendments.
Sure. Namoga's witnesses Felix and Sporich each claim that the financial assurance requirements in the applicant's petition exceed OCD's statutory authority under the Oil and Gas Act and may even be a taking. Both suggestions are incorrect. In fact, the Act requires the Commission to establish categories of financial assurance after notice and hearing. Applicant's expert Peter Morgan went into some detail on this earlier in the hearing, as you all may recall from just now. Suffice it to say, marginal wells, inactive wells, and wells belonging to operators with risky portfolios are all cognizable categories under the Act. As for takings, to my knowledge, financial assurance requirements have never been considered a taking anywhere in the country. The fact that the Act provides for the Commission to conduct rulemakings to set amounts implies that such amounts may change, insofar as amounts determined sufficiently to reasonably pay the costs of plugging the wells covered by the financial assurance certainly change over time.
Can you speak to the issue of administrative burden on operators?
Yes, this is something that applicants want to minimize, both for the regulator and the regulated industry. Namoga witnesses Emmerich, Arthur, and Felix raised concerns about alleged administrative burdens, including of obtaining numerous single well financial assurance instruments and high volume blanket bonds, claiming those amount to a moving target, and that updating bond amounts will be difficult given merger and acquisition activity, and that operators would need to constantly recalculate bond amounts. We understand these concerns, which is why applicants structured the proposal to allow any number of required single well bonds to be rolled up into a single financial instrument. Maybe we'll call them multi-well bonds. Further, updates to bonds for marginal wells occur only once per year, and at least the first cut of what needs to change could be provided programmatically by using the OCD's data management system. We strongly believe this system is workable.
Let's turn now to the question of whether the proposed amendments reflect risk-based financial assurance.
This gets to the core issue of this rulemaking, which is about identifying the risk of well orphaning and pursuing risk control strategies consistent with the state's charge to protect taxpayers and the environment. There appears to be widespread agreement that the OCD's approach to financial assurance should be risk-based. We certainly think so, and so do Namoga witnesses Felix, Emmerich, Arthur, and Izel, according to their testimony. Our structure targets wells we believe to be at risk, at elevated risk of becoming orphaned, i.e. inactive and marginal wells, as well as operators whose large portfolios of such wells evince a structural risk of inability to meet plugging obligations. The particularities of our proposal come in large part from OCD regulators' on-the-ground experience overseeing the industry in New Mexico, which then formed the basis for establishing the production and timing threshold aimed at capturing the most at-risk wells, all of which has been borne out through data and analytics previously presented. The approach is both nuanced and targeted for ease of implementation. For example, the marginal well definition includes both an annual production threshold and a days per year of production threshold. This is because OCD regulators see a materially different orphaning risk from wells that produce exceedingly little over the course of a year and wells that are operated only occasionally, arguably to maintain their active status. All of that said, our structure is clearly not the only way to do risk-based financial assurance. We could have gone with a structure that involved greater well-by-well consideration. For example, operators could be required to provide details of asset, liability, and cash flow reports to allow the OCD to conduct a detailed forensic risk analysis on a per-well basis and across operator portfolios. But operators would likely have resisted such a framework as being overly intrusive while also being burdensome on the regulator. Instead, our proxies for risk are simple, transparent, and public, and thresholds can be determined by an automated data query. Nevertheless, we have long been interested in industry's articulation of risk-based financial assurance. Yet despite industry witnesses' calls for such a system, no specific proposals have been proffered. In the absence of that, in my view, our structure is appropriately tailored to the risks as OCD experiences them, as well as conservative with respect to the wells and operators that will be subject to heightened financial assurance and the New Mexico taxpayer burden. I'd also like to address the 15% high-risk well threshold for fleet-wide single well bonding. As illustrated in Applicant's Exhibit 68, also presented in my summary of direct, the 15% threshold reflects a natural breakpoint in the ratio of potential liability versus revenue generation across the landscape of New Mexico's operators. The graph illustrates that all operators below the 15% marginal inactive well threshold, those in green, appear to have produced at least enough revenue in 2024 to cover estimated plugging costs, though not necessarily reclamation, for at least their marginal and inactive state and private wells. Meanwhile, the only operators that fail to meet the criteria are all above the 15% threshold. This suggests that portfolio composition does serve as a meaningful indicator of structural financial risk, namely that an operator may not be able to generate even this modest amount of gross revenue relative to expected future costs that could fall to the state on its account. As a final thought, I note that a portfolio composition metric also acts as an incentive for operators to increase their production, to plug their non-economic wells, or to transfer them to a company able to demonstrate the ability to pay for proper end-of-life closure. All beneficial courses of action, socially or economically, that may reduce the risk of eventual orphaning.
Let's turn to industry concerns that applicants' proposals are unfair to small operators. What is your response?
Several witnesses, including IPA&M's Murphy and Gilstrap, raised concerns about the impact of this proposal on small operators, suggesting that the proposal targets such operators. This is untrue. The plain language of the proposal is no more discriminatory with respect to operator size than the existing requirement that operators be able to pay to properly plug and abandon their wells. The criteria for marginal wells are low production levels and sporadic operation over time, not size of operator. These two criteria apply to small, medium, and large operators alike. All operators in New Mexico, regardless of size, are obligated to obey the law, and plugging and remediation requirements are significantly long-standing as to predate any current New Mexico operator. It is not at all the intent of this proposal to curtail small operator viability. Responsible operators who are not, in the eyes of surety companies, at elevated risk of orphaning their wells should continue to be able to obtain financial assurance bonds at pennies on the dollar. Moreover, if the concern is that an independent operator would no longer qualify for bonding, a number of steps could be taken. Operators can minimize the number of wells for which they would need to put up $150,000 bonds by plugging idle wells, ensuring production of their marginal wells for more than 180 days a year, and reducing their populations of idle and marginal wells to below the 15% threshold. Small businesses are the lifeblood of communities. At the same time, it is neither appropriate nor socially beneficial to subsidize any business operations at the expense of taxpayers and the environment by minimally enforcing plugging requirements. The reforms in applicants' proposals are risk-tailored to eliminate persistent orphan wells and should not threaten the viability of operators who have incorporated asset retirement costs into their business models. In the context of EDF's bonding snapshot analysis, a look at how the 15% marginal and inactive threshold falls across operators of various size shows that around 2/3 of operators with 50 or fewer wells appear to exceed this threshold, placing them in the higher risk group with higher bonding requirements. Nearly half of operators with 51 to 500 wells fall into this higher risk categories, while only 14% of operators above 500 wells do. However, this distribution reflects the reality that many small and medium-sized operators are holding a larger percentage of marginal or non-productive wells within their portfolio. To the extent that impacts of applicants' proposed rule fall disproportionately on small businesses, that reflects the fact that the majority of small to medium-sized operators are already at apparent risk of being unable to meet their existing future plugging and remediation obligations, given apparently low revenue levels for the assets that they eventually must pay to plug. In addition to estimating the bonding amounts required under the applicant's proposed rule using a snapshot of 2024 production, EDF also estimated total revenues for each operator in the data set as included in applicant's Exhibit 68. We can compare these estimated revenues with estimated costs of premiums for surety bonds for the amounts needed to meet bonding requirements for their wells. An annual premium for an operator expected to be able to meet their responsibilities would fall accordingly in the range of 0.5 to 7%, with lower premiums for around 1% for companies considered more investment ready and rates up to 5% for companies deemed speculative or higher risk. Applicant's Exhibit 84, there you go, summarizes comparisons of these amounts across operator groups of different sizes. If we look at all operators with fewer than 50 wells as a group, 1% of the group's collective bonding liabilities amounts to 0.25% of their total revenues. 5 times this, representing a 5% surety premium, instead is still only 1.25%. This measure varies across the group. For operators of 50 wells or fewer that are above the 15% marginal and inactive threshold, the equivalency of 1% of liability for the group is closer to 0.75% of revenue, or at a 5% premium, 3.75% of revenue, while for the same size operators below the 15% threshold, the equivalency is only 0.034%, or at a 15% premium, 0.17% of revenue. There is, of course, variation within these groups at the level of individual companies, especially given that some very small operators are not associated with any production or estimated revenue in the data set, meaning that there is no revenue to divide the liability by in the calculation. However, for the productive and financially healthy operators, those gauged to be low risk by a bonding entity, the financial impact of an annual surety payment will likely fall well within the expected range of typical revenue fluctuations as oil and gas prices vary. Conversely, the operators who would find these increased bonding requirements burdensome are more likely those that were also already going to struggle or fail to meet their obligations for well closure. Pushing up the timeline for this eventual revelation to before the actual orphaning of these wells provides an opportunity for a different outcome, such as returning the well to production or increasing production through workover if realistically feasible, or transferring their unproductive assets to a more capitalized operator who can meet the bonding needs before its value has truly fallen to zero.
Similarly, many industry expert witnesses presented concerns about impact to marginal well operations. What is your response?
NMOGA witnesses Felix, Sporich, and McGowan, and IPA&M's Mitchell all raised concerns about marginal wells. Some of these concerns may owe to a misunderstanding of the definition of marginal wells in this proposal, i.e. those producing less than 1,000 BOE per year and for fewer than 180 days per year. This is a much narrower definition than the common federal definition of marginal wells, which is less than 15 BOE per day or less than 5,475 BOE per year, with no exception for the number of days producing. As amply demonstrated earlier by Mr. Purvis, the percentage of marginal wells as defined in New Mexico is relatively small. IPA&M witness Ezel has speculated on the relationship between heightened financial assurance requirements for marginal wells and New Mexico legislation that provides a production incentive tax for stripper well properties. This is worth exploring. The stripper well tax policy covers wells producing under 10 BOE per day or 3,650 BOE per year. In contrast, applicant's proposal merely puts an insurance policy on wells when production levels reach less than a third of the tax policy amount, accounting for the increased risk to the state that such wells become orphaned. While I cannot speak for the legislature's intent relative to the tax policy or anything else really, it is hard to believe that the goal was to allow low-producing wells to be run into the ground, leaving cleanup liability to the public. Indeed, the LFC, no stranger to New Mexico tax policy, recommends in its recent report on orphan wells that rules be promulgated for low-producing wells, producing less than 750 BOE per year or less than 2 BOE per day, be required to post individual well financial assurance. All that said, operators could use the taxes saved on low-producing wells to support bonding and plugging activities. Moreover, it is possible that the production, restoration, and workover projects subsidized by New Mexico taxpayers through the stripper well tax policy, coupled with applicants' proposed amendments, can incentivize operators to keep more wells highly productive and thus avoid heightened bonding requirements.
Some industry witnesses have raised the specter of premature well plugging as a result of the proposed regulations. What is your response?
NMOGA witnesses McGowan and Arthur raised this point several times, making the contention that accelerated plugging of end-of-life wells does not provide environmental benefit and conflicts with legislative efforts to allow non-productive wells to be beneficially repurposed for energy storage and the like. From my perspective, if marginal wells as defined are able to support the cost of plugging, I do not see why they would be plugged prematurely. On the other hand, if wells within the marginal definition are not able to support the cost of plugging, then there is something wrong with the business model and thus the need for a policy corrective. On the topic of benefits from well plugging, first, there is clear documentation of increased risks from environmental exposures and human health impacts resulting from unplugged or improperly abandoned wells, as previously noted. For environmental hazards of unplugged wells that grow more likely or more significant over time, a longer time frame prior to plugging clearly leaves more opportunity for these contamination events to occur. Finally, on the relationship between the potential future beneficial uses of end-of-life wells and the 8-year limit on inactive wells, except in extremely limited circumstances, wells that have not been used for 8 years or will not come back into production or be used for another beneficial purpose. This is supported by my direct testimony and applicant's Exhibit 13, which demonstrates that 99.5% of inactive wells are reactivated do so before 8 years of inactivity. Many in the advocacy community were worried that the advent of beneficial uses for wells outside of oil and gas production and waste disposal would merely serve as an excuse for operators to idle their wells forever and never plug them. I personally made the argument that these alternative uses were important to pursue, first, for their potential contribution to clean energy development, and second, as a potential revenue source for eventual plugging. I am disheartened, although I suppose not surprised, to see this potential weaponized by industry to avoid plugging liability. I do think that the 8-year window to make use of the well strikes the right balance here.
What is your response to concerns expressed by industry witnesses Arthur, McGowan, and R. Scott about reduced capital access and marketability for wells upon transfer?
Generally, capital for oil and gas production will continue to flow to New Mexico regardless of financial assurance considerations. The high productivity of the Permian is a natural draw for capital. Generally, operators with business models that include accounting for legally required well plugging obligations will continue to have access to capital. I posit that the applicant's proposed rule only reduces the marketability of marginal and inactive wells to the extent that well plugging and remediation costs would be internalized to the operator rather than externalized to the public. To me, this argument sounds like you're hurting our business because you're not allowing us to break the law anymore. And if anything, industry's argument supports the commission's adoption of the proposed amendments.
Industry witnesses have questioned whether the financial assurance components of the proposal will indeed accomplish the goal of reducing future orphan well burden in New Mexico. What is your response?
IPA&M witnesses Gilstrap and Murphy raised questions about whether increased financial assurance might have an unintended consequence of increasing well orphaning and wonder whether bonding can protect the state against bad actors. In my opinion, if an operator cannot meet their financial assurance obligations and chooses to walk away from their legal plugging responsibility, the financial assurance obligation could not be said to have caused the orphaning, but merely to have revealed an inevitability. I question in these cases whether the operator would ever have been able to pay for plugging and remediation, and whether the operator failed to internalize their liabilities as part of their business model. The intent of applicant's proposal is not to cause well orphaning. However, internalization of plugging and abandonment costs through the proposed rules to operators who have not been planning or setting aside funds to account for this inevitability could, on the margins, result in acceleration of orphaning that would have occurred eventually. But where operators do walk away, the state should want to ensure that there is sufficient funding in place to cover the costs the state will incur. Finally, applicant's proposal aims to protect taxpayers from high-risk operators going forward by making it more difficult to transfer end-of-life wells to those bad actors, both through increased scrutiny on transferees and their compliance history and ability to meet regulatory obligations, and the bonding structure which disincentivizes concentrating low and non-producing wells under limited liability companies designed to facilitate revenue dispersion to shareholders and well orphaning.
You identified there were a few one-off issues you wanted to address. What are those?
Yes, in particular, I'd like to discuss the relationship between inactive well integrity and orphaning risk raised by Ezel, the role of lease retention and operator plugging decisions raised by Arthur, and the experience in Colorado raised by Gilstrap. On well integrity testing for inactive wells, it's true that these tests help ensure an inactive well has integrity, but they do not ensure that the operator of such a well has the financial wherewithal to ensure plugging and remediation. That is why heightened financial assurance is required in addition to regular integrity testing. On the role of lease retention in decisions whether to plug a well, operators often use submarginal wells specifically to hold leases in the hopes of accessing other formations over time. This practice deprives mineral owners of maximum returns and locks them into minimal royalty payments while the operator waits around for new opportunities. If the operator chooses to plug their submarginal well rather than furnish a bond to ensure the well will be plugged, eventually, with operator financing, the mineral owner then gets an opportunity to negotiate new terms for their minerals with new operators and ultimately avoids waste from indefinite idling. Finally, on Colorado, Namoga witness Gilstrap contends that the rule changes there caused decreased bonding and increased orphaning. Colorado's financial assurance rule implementation has been complex, and there are at least two different total dollar amounts to track. One is the amount required by the rules, and the other is the amount that Colorado has in hand for plugging. On the first, Colorado did anticipate that the total amount required by rules might initially dip after the rules went into effect, based on which plans operators selected, with certain options having relatively low year-one amounts that would build over time. On the second amount, in April 2022, Colorado had roughly $243 million on hand for well plugging. And as of September 2025, that amount had increased to roughly $390 million on hand for approved financial assurance plans. This, of course, is complemented by the fact that industry plugged roughly 1,600 wells in 2022, 1,800 wells in 2023, and 1,200 wells in 2024. Both of these trends are, on balance, reducing the risk to the state. On the second topic of orphan wells, Colorado has seen an increase in wells formerly orphaned by operators. With the financial assurance rules, Colorado also included a registration requirement that has created an opportunity to work through the entirety of the Colorado's operator list and work to bring operators into compliance. The reason operators have orphaned wells are myriad. Operators in Colorado continue to fund an orphan well mitigation fund that the state has used to complement the federal spending over the last 2 years and provides an industry-funded resource of around $10 million per year above and beyond severance tax revenue for work to reclaim, plug and reclaimed orphan wells. While the complexity of Colorado example can be expected, given the magnitude of the changes undertaken, it is disingenuous to cast the state's effort to get ahead of its orphan well problem as ineffectual and should certainly not be used as a cautionary tale to disincentivize New Mexico to do the same.
Mr. Peltz, thank you for the summary of your rebuttal testimony. Madam Hearing Examiner, that concludes applicant's summary of direct and rebuttal testimony, and we now move to admit applicant's exhibits 1 through 88.
Are there objections to applicants' exhibits 1 through 88? I'll pause for a moment. Mr. Cloutier.
I would like to ask the witness some questions about Exhibit 7 before you make a decision on admitting it.
All right, go ahead.
Should we put it up?
Yeah, unless you can otherwise direct our attention to it.
Yes, can I ask Ms. Tripp to put it up if it's time to ask the questions?
Yeah.
Or Jacob?
Yes, I'll grab it.
It's Bates 241. The OCD inactive well search list.
Okay, it should be displaying on your screen, Exhibit 7.
Yes, we could see it now, Ms. Tripp. Thank you. Just need to get to the next page. And blow it up for these old eyes too, please. Yeah, thank you. Mr. Peltz, my name's Drew Cloutier. We've met informally. I represent IPA&M. Good afternoon.
Good afternoon.
Do you recall that during Mr. Alexander's testimony, some questions came up about the data in this, and he indicated that this was an EDF prepared exhibit?
I think so.
Okay. So can I get over next to Jacob to take a look at the switch chairs? Thanks. Yep. There was a time I could have read that with no problem, but let me get close to it.
It's a little fuzzy too.
Yeah. So there was a question here. Who gathered this data? Was that the folks that you talked about at the beginning of your direct
Yes,
testimony?
EDF's economics team.
Okay. And there are 3 inactive well lists in evidence from OCD. I think they're exhibits OCD 21, 22, and 23, if I remember correctly. You know, which of these was used?
I do not.
Okay. The principal question, though, is this exhibit was used to talk about wells that were inactive and out of compliance. Do you recall that?
Yes.
What is the form of non-compliance that was used here to create that category?
I believe it means either expired TA status or not in either the approved or expired TA status.
Okay, and no other compliance issues besides those 2 that was used on the sort?
Not to my knowledge.
Here, okay, and that, I think that was Mr. Alexander's testimony, and I just wanted to be sure what the non-compliance was before I agreed to admit this exhibit.
Just relative to inactivity.
Okay, and so, for instance, it would not be valid to look at this and say these wells are out of compliance for methane emissions, for instance?
No, it shouldn't be used for that purpose.
Okay, thank you. Madam Hearing Officer, I would do not have an objection to the admission of Exhibit 7.
All right. I'll pause for another minute in the event there are objections to any of the 88 exhibits proffered by applicants.
No objection from NMOGA.
Thank you. All right, exhibits 1 through 88 are admitted. Mr. Tisdale, was there going to be rebuttal?
No rebuttal, Madam Hearing Examiner. Mr. Peltz will now stand for cross-examination questions from
unless, of course, we want to take a break.
Yeah, that's what I was about to say.
That would be fine as well.
So let's come back at 3:20, please. Let's come back from the break, please. All right. Mr. Cloutier, are we starting with you?
Nimoga will actually be starting with Cross.
All righty.
Madam Hearing Officer.
Mr. Swazo.
Mr. Peltz, good afternoon.
Good afternoon.
You know, I saw that you went to the University of Chicago, and something I've always wanted to know about the University of Chicago because I was told something about it, and I've never had the chance to ask somebody. But my professional mentor told me that there's a motto at the University of Chicago, and I always suspected she was lying.
No,
But I couldn't
she
prove it.
wasn't lying. It's true.
She said that the unofficial motto was the University of Chicago, where your very best simply isn't good enough. Is that true?
Oh, I thought you were going to say where fun goes to die.
Oh, no, that's a good one too.
Yeah.
Fair enough. Either way, that sounds traumatizing.
A little bit, yeah.
Very good. Well, we appreciate you coming here to testify this afternoon. I know it's been a long day and a lot has gone into this. So I'm going to start with some of the similar questions that I asked your colleague,
Sure.
Mr. Morgan. You're not licensed to practice law in the state of New Mexico, correct?
I am not.
Okay. And you are licensed to practice in, I think, one state, New York?
Correct.
So when you interpret the Oil and Gas Act of this state, you're offering a legal opinion about a state where you don't have any actual experience, correct?
Well, I'm really more here as a subject matter expert than as a legal expert per se. I'm happy to try to answer legal questions. I'll do my best, but that's not my primary function.
Okay. So it's your testimony here, you're not offering legal opinions?
Well, it might happen. We'll see.
And since you graduated law school, you've only been employed as a lawyer at EDF, correct?
Correct.
Okay. And you've never practiced law in any other capacity other than your role as EDF?
Correct.
Okay. Now, I'd like to know a little bit more about EDF. It's an sorry, I can't talk today. It's an environmental advocacy organization that frequently takes positions adverse to the oil and gas industry. Is that fair?
Well, I don't know if I would say adverse, but the general thesis of EDF's energy work is that all energy production should internalize their externalities. And then, from there, kind of let God sort it out. And so sometimes that means, talking about methane and that sort of thing in orphan wells. But EDF is notably not a keep it in the ground organization. Okay. We recognize that fossil fuels, I certainly couldn't have got here without fossil fuels.
But EDF has actively petitioned, I think you mentioned, or intervened in multiple states in oil and gas rulemakings, correct?
Yes.
Now, you're currently engaged by WELC in this matter to advocate for regulatory changes in New Mexico, correct?
Yeah, that's fair enough.
Okay. Now, you've never been a general counsel for an oil and gas company?
No, I have not.
You've never advised companies on compliance with the New Mexico Oil and Gas Act?
No.
Or OCD regulations?
No.
Okay. But you are here telling this commission and, essentially those who have to abide by rules in the state of New Mexico, what EDF thinks or you think should be done to make those rules better, correct?
Yes, but it's ultimately up to the commission to decide what to do with my opinions.
Fair enough, but your opinions are not predicated on experience in the state.
No, although, I've spent a lot of time with oil and gas regulators, including New Mexico oil and gas regulators. I don't think I've missed an IOGCC meeting since 2013, and I've barely missed a GWPC meeting. Spent a lot of time with oil and gas regulators trying to understand what their issues are, how they think about them, watching regulators talk to each other about their problems and that sort of thing. So I have experience based on that. Also, I was trained by the former executive vice president of TIPRO, the Texas Independent Producer and Royalty Owners Association in Texas. So I have a little bit of industry perspective.
Fair enough.
That way.
I'd like to ask you a few questions about slide 3 of your demonstrative exhibits, and my colleague Jacob Everhart is going to pull that up in just a second. So slide 3 of your demonstratives identifies the LFC report as comprehensive. Is that accurate?
Yes,
But,
although not necessarily complete.
okay. Now, you don't disclose on this slide that you advised the LFC while working for EDF, do you?
I don't think so, but they emailed to ask for a presentation, and I gave them one. I think that was in my summary.
Okay, so you provided input on the presentation.
Yep.
Okay. And you chose to highlight in your slides those LFC findings that support EDF's policy goals. Is that fair?
Well, we came up with our ideas before LFC, so there's alignment, but it's not the order where they suggested it and we thought, okay, great. It was kind of the other way around.
Okay, but in your recommendations to the LFC, you didn't address OCD's existing bonding authority or any of OCD's authority, correct?
Well, I'm trying to remember what I said on the call. I mostly just reported out on what we've seen in the data and what other states have done.
Okay, so your findings, I guess, focused to the LFC on your findings relevant to orphan wells?
Yeah,
Okay.
not dissimilar material to what I presented to you all.
Okay. So is it fair to characterize EDF's activity across these states as, their engagement in multiple state level rulemakings?
Yes.
Okay. And so New Mexico is just another one of those efforts by EDF?
Well, not just another one. It's an extremely important one because New Mexico is such a critical oil and gas state.
Okay. But you're doing this in other states just like you are here?
Yes.
Okay.
Yeah, it's a state level issue. You can't, there's no federal solution to this. This is each state on its own has to figure it out, but they can all learn from each other.
Okay, and so in your testimony, you cite the LFC report to support the need for increased bonding and plugging requirements. Is that fair?
Sure.
Are you aware that the LFC report itself cautions that the records associated with orphan wells may be missing or incomplete?
Yes, and I know that independently.
Okay. And just to recap, from your direct, you acknowledge that New Mexico does not have yet a consistent definition of orphan well?
Correct. A few states don't. New Mexico is one of them. There's a good IOGCC report on this from a few years ago where each state explained what is our definition of orphan wells, how many do we have, what do we do to try to deal with it. New Mexico contributed to that report. It's not an exhibit, but I'm just so you know.
So the LFC report, New Mexico statutes and regulations don't have a basic definition for orphan well. Is that fair?
Yes.
Okay.
Although there does seem to be a fairly recognized definition. OCD was able to report 1,700 to DOI as part of its notice of intent to apply for formula grant funds in December 2021.
Okay. But just to put a finer point on it, there is no bedrock definition of what an orphan well is, but you're seeking to address an orphan well problem, correct?
Yes, I think that there, practically speaking, there's clearly an orphan well problem, even if orphan wells aren't defined as such in the state.
Okay. Now, staying with slide 3 of your demonstratives, that tells us that orphan wells will cost the state more than $200 million. Is that accurate?
I believe that was LFC's estimate for the current orphan well burden in the state, yes.
Okay. Did you independently verify those costs through OCD plugging data?
I don't know if I did, but we might have.
When you say we, I'm asking just you.
Oh, well, I might have.
Maybe, but maybe not. All right.
So many exhibits,
Let's look at slide 5. Now that lists approximately 1,700 orphan wells and 3,000 at risk of orphaning. Is that accurate?
I think it's 1,700 orphan wells and then 1,400 inactive wells and 3,000 marginal wells.
Okay. Are you aware that the OCD reports, they have to submit an annual report? Do you remember those from your package of exhibits?
No.
Okay. Would you take my word that they issue a report every year?
To who?
To the state of New Mexico, I guess, or to the governor?
Yeah, I believe you.
Okay. Are you aware that one of those reports from 2024 lists fewer wells meeting that definition of orphan?
What's the number? Oh, I can't ask you questions. I'm sorry.
I don't know the number. I don't want to belabor that point. I'd like to move on to some other issues.
I know that the state's been plugging wells,
Right.
with federal funds. And I know that they're paying more attention to plugging wells than to putting new wells on the list at the moment.
Mhm.
Since there is only barely a procedure for that anyway.
Now let's look at slides 15 and 16, which are exhibits 61 and 62. And those show wells in expired temporary abandonment status. Is that right?
Looks like it.
Okay. You haven't analyzed whether some of those wells have since been reactivated or plugged, have you?
I'm not sure explicitly, although we definitely have exhibits that look structurally at reactivations, but I don't know explicitly about if we looked at expired TA well reactivations.
Okay, so you can't show me one way or the other whether or not you have or have not.
For expired, we definitely did not look explicitly and specifically at expired TA wells and their frequency of returning. It would be an interesting analysis to see these different categories. Is there a difference in the return rate and time? But we didn't do that.
Okay, let's go on to slide 27, which is exhibit 69. And I think, as I understand that, that actually shows wells that were reactivated after a period of inactivity. Is that true?
Yes, it shows the trend line for wells that went from active to inactive, and also the trend line for wells that went from active to inactive.
Okay. I think I'm done with the slides for a little bit. I'd like to move to your direct testimony, particularly page 8, lines 12 through 16. And I believe that in that portion of your testimony, you state that the LFC sought you out personally to help support its work product reporting on New Mexico's orphan well problem. Is that accurate?
Yes, they sent me an email.
Okay. And approximately 1 month after the LFC contacted you, you gave a presentation to them, correct?
I don't remember if it was a month, probably something like that.
But you did give the presentation?
Yeah.
Okay. And more or less 1 month after that presentation, the LFC published this report giving an overview of the orphan well problem, correct?
I think so.
Okay. Now, you told the commission that the LFC agrees with you that reforms are necessary, correct?
Broadly.
Okay. But you personally contributed to the formation of that report.
Me and many others. I understand LFC spoke to people like me and also the OCD and industry and academics, but I don't know exactly who they spoke to.
So you don't know for certain whether or not they spoke to industry?
Well, I specifically asked them and they said, yes, they spoke to industry. And I said, could you say who? And they declined to answer me.
Okay. So is it fair to characterize the figures or the estimates that you use for orphan wells as based on the LFC's numbers?
No.
No?
We developed a lot of this before, and the basis of our numbers were from the OCD database, from GoTech and Enverus.
Okay.
There's some, but not 100% consistency with what we came up with and what they came up with. They did their analysis independent to us.
Okay. Now, Mr. Peltz, as an attorney, you're aware that many areas of the law are dependent on state-specific case law, correct?
Yes.
State-specific statutes, yes?
Yes.
Okay. So generally speaking, would you agree that matters concerning state agencies like the OCD are bound by state-specific administrative legal doctrines?
Sure.
And would you agree that generally speaking, each state has its own specific corporate and constitutional matters?
Yes.
Let's move on to Namoga witness Clayton Sporch. You reviewed his direct testimony and rebuttal testimony?
Certainly the pieces where there was something relevant for me.
Okay. And sure, there's certain places, for example, marginal well, where you say that the potential to reclassify non-marginal wells as marginal. And you think that he conflates that definition of marginal with inactive, is that right?
Well, what I was concerned about is, some people think of marginal wells as less than 15 BOE per day, and naturally, because that's the standard definition. We adopted a specific definition of marginal wells of less than 1,000 BOE per year and less than 180 days of production a year. And it's easy if you're not getting into the weeds of the proposal to not realize that. And so I don't really know if that's what happened for that witness, but that's just a thought that I wanted to share with you all.
Okay. But in your rebuttal, I guess I should say, you don't specifically rebut Mr. Sporch's examples. Is that fair?
Do you want to share what those examples are?
We can pull up the testimony. Yeah. Yeah, it's rebuttal page 4. Peltz. Actually, let's table that and we'll come back to that because I want to cover some other topics with the time that we have. So just to be clear about applicant's proposed definition, they treat any well that produces under 180 days as marginal, correct?
No, it also has to be under 1,000 BOE per year.
Okay. And that's how the proposed rules from the applicants measure it, right?
Yes.
Time and volume.
Mm-hmm.
And does that include wells that are temporarily offline due to pipeline maintenance or really any other issue that might occur in the oil field?
Well, those would fall under inactive if they've been active for more than 12 months, something like that, 12, 13, 15 months. And so if you're just doing taking it offline for, an operation, I'd imagine it would be less than that amount of time and it wouldn't change the the status of the well.
Okay. Did you consult with any OCD engineering staff or other staff before concluding that 180 days was the appropriate cutoff?
Well, it was their idea.
Okay. And you didn't verify that independently outside of OCD or talk to anybody?
Well, it's kind of based on their judgment of when those wells start to become risky. I think I said in either my direct or rebuttal summary that if a well is producing every day versus if it's producing only sporadically has an impact on how risky that well is of going into orphan status. According to OCD, I believe them. They're the ones who do it every day.
Do you know why they chose 180 days?
I think it felt to them like the right cutoff, but you'll have to ask them exactly.
Certainly. Let's talk a little bit about Colorado and California, which you raised in your testimony. And I guess you would describe that as that they overhauled their financial assurance systems. Is that right?
Colorado certainly did. California's was a little bit more surgical.
And that was specifically to address the orphan well problem, or?
Yes.
Okay. Now, do you know whether those states have their own statutory mandates that underpin those overhauls of the rules to address the orphan well problem?
Colorado certainly does.
Okay.
There was a bill passed as part of a omnibus set of laws. They pass bills on oil and gas all the time in Colorado.
Okay.
And one of them specifically directed the agency to do a rulemaking. The California reform was actually legislative and not regulatory.
So that means that those states required legislative changes as a predicate to implementing rules to address that problem?
No, not required, but there was a legislative change, and so they acted. If they had wanted to do it on their own, they could have done that also, based on their, organic statute.
And it's your interpretation of New Mexico statutes that a legislative change is not needed to implement the proposals that applicants are proposing, correct?
No, I understand the process is a petition that ends up in these hearings.
Right, but you're saying they don't need any statutory changes, was my question.
No, I don't think so.
Colorado's financial assurance changes occurred following legislative changes, correct?
Yes.
Okay. Now, you've highlighted Colorado's financial assurance changes as a success story, is that right?
Yeah, so far. Now it's going to take years and years and years to really know, but they put a lot of thought into it. They had a lot of stakeholder conversation with industry. They eventually came to a consensus. They came up with six different options for what operators could pursue under various circumstances. It's pretty ornate.
But you've admitted that orphan wells, they're doubled and then quadrupled after they changed their rules, right?
Yeah, they pretty much knew that was going to happen because a lot of wells were inevitably going to become orphaned no matter what. If an operator does not have the money to plug their wells, no amount of financial assurance is going to fix that, but that's why they established this orphan well closure fund, which is $225 per well per year from large operators and $125 per well per year for small operators, with the goal of making a $10 million a year fund. And so between that and the federal funds they were getting, they thought that would probably cover all the likely orphans coming in the coming decades. Now, if they realize that that's not enough, they can adjust those dollar amounts to collect more money for this purpose.
But I guess the takeaway that I drew from your testimony is that the increase in orphan wells occurred after the bonding amounts were increased, right?
Well, yeah, but that's not necessarily a causation.
Okay, but it's certainly an outcome.
Well, if operators aren't taking care of their wells, if they don't save enough money to plug their wells, they're going to become orphaned, and that's a real shame. The idea is that you want to plug these wells as quickly as possible. So if it's the operator who's able to do it with their own money, that's obviously ideal because it seems like they can do it more cheaply. If it can't, it has to go to the state, and the state needs to be fully financed to cover those costs.
Fair enough. But in this case, I think it's fair to say that the increase in bonding led to the consequence of more orphans, right?
Well, it's hard to say if there's more. I guess I did say there's more orphan wells now. So, but, they have a bunch of money to plug the wells. So when I spoke to the regulators there, they're not worried and they feel pretty comfortable with how it's going.
Let's talk about slide 22, rebuttal exhibit 68, which I'll let you get there. Is that up on your screen?
No, I see exhibit 10. There we go.
So this slide, as I understand it, compares operator revenues to plugging costs, but those figures are gross revenues, not net after taxes and royalties. Is that accurate?
Yes.
Okay.
And it's an annual revenue versus the cost to plug. It's an illustrative plot.
And as I understand that, that shows around a 1% impact, right?
No, I don't think that's what this slide is about.
Let's move on to slide 18. Now, this slide, sorry, okay. This slide assumes every marginal well will eventually be orphaned. Is that right?
Yeah, this is a no, this is showing the estimated bond requirement and the estimated plugging cost of all operated wells. And what it shows is that if the commission adopts applicant's proposal as written, the wells, the operators that have increasingly high number of their wells in marginal or inactive status get closer and closer to the full cost to plug their wells.
And would you say this models, I guess, a worst case scenario?
Something like that. I think what it indicates, it shows that the proposal is risk oriented. The riskier the operator, the closer to 100% bonding would result from the proposal, if that makes sense.
Okay.
And that's what you want for public policy.
In your opinion?
In my opinion, yes.
Let's talk a little bit more about the statute, which you discussed in your direct summary 70-2-14A for authority to create new categories of financial assurance. That's the statute you rely on for that authority, correct?
Yes.
Okay. But that statute also has an express cap of blanket bonding at 250,000. Is that right?
Do you want to put it on the screen? We could do the rainbow one again.
No, I don't think we need to. I think everybody's familiar enough with it, but there, it does say 250,000, right? Blanket bond. I mean, I'm glad to if you need it.
Why don't we? I think it's always helpful to have.
You have that? Yeah. You're the rainbow guy.
Everyone has the rainbow.
Of course I have.
I don't have it. That's Adam's creation.
Always have it. That's always on my screen. Go.
It's an important provision.
Now, Mr. Peltz, would you agree that nothing can change that $250,000 cap other than legislative action?
For that category, but it doesn't preclude the commission from making new categories. That's the first sentence.
Understood. But that $250,000 cap, that would require a legislative change for anybody to alter, right?
Yes, the green one, yes.
Okay. Now, there's no express statutory language authorizing $150,000 well financial assurance, is there, in that text?
Well, the purple line says one well plugging financial assurance in amounts determined sufficiently to reasonably pay the cost of plugging the wells covered by the financial assurance.
Thank you.
And so I think it gets you there.
But it doesn't expressly say 150,000, does it?
No.
So for the commission to adopt your proposal, they would have to read into that statute the authority that you claim is there, correct?
Yes.
And if the commission did that, wouldn't it effectively be amending the statute by rule?
No.
Why not?
Well, because sentence one is the division shall create categories of financial assurance. And so, creating the categories is a thing that they're allowed to do. And in fact, they're required to do, shall. And so I think it's totally consistent with the statute.
As a non-New Mexico lawyer, that's your statutory interpretation.
Well, it's just a plain reading.
Well, it is your plain reading, but I think on direct, you said something to the effect that blanket bonds are a privilege, not a right. Do you remember saying that?
Yes, that's in Utah. That's what the Utah regulators are saying.
Okay. But the $250,000 blanket bond is a statute in the state of New Mexico, correct?
It's just one possible category.
But it's expressly stated there, right?
Well, yeah, but it's not exclusive with new categories.
Okay. There's nothing in that statute that allows the costs of plugging to also include costs associated with reclamation, is there?
I don't believe so.
Okay.
We're kind of just having to let reclamation go. It's super expensive. Sometimes it's several times the cost of plugging, but it's not in here, so we didn't do it.
Okay. Sorry, I'm going through my questions, and I think you touched on a lot of these indirect, so I'm going to try not to answer it so we can all save time.
I'm not in a rush.
So just to make sure I understand, applicants are proposing a change that does not consider plugging costs associated with the depth of the well, correct?
Implicitly, yes, because they took the average cost for all of the wells that OCD plugged and then came in $13,000 under that.
Okay, but those are not specifically in your proposals, right?
What's not?
Depth?
It isn't.
Now, do you remember when I asked Mr. Morgan about the two primary duties of the commission with respect to prevention of waste and protection of correlative rights?
Somewhat, mostly.
Okay. Did you do any sort of analysis of New Mexico law, New Mexico cases in determining what the commission's statutory authority is as part of your direct testimony?
I didn't.
So this commission is not going to hear from a New Mexico lawyer that has advised companies or gone before the commission or the division on the proposed changes by applicants, correct?
I think the OCD lawyers are New Mexico lawyers.
But they're not witnesses in this proceeding, are they?
Some of them might be. I don't know.
I don't think that they are.
Well, there's certainly a bunch of them in the room.
But they're not witnesses. They're not providing testimony to this commission.
It's a weird way to set it up, I think, actually.
What is a weird way to set it up?
It would make more sense to me if more of these people could talk, but this is the system we have, so here's how we're doing it. I know there's a New Mexico lawyer on the commission.
Don't drag me into this.
Ooh, the commissioner, the chair rules.
Some of the stuff I'm not gonna remember.
Namoga has no more questions for this witness, Madam Hearing Officer. Thank you, Mr. Peltz.
Thank you.
Thank you, Mr. Swazo. Mr. Cloutier?
Sure thing. Can we get Ms. Tripp to have authority to share screen, please?
Yes.
I believe I have authority. What exhibit would you like pulled up?
Oh,
It's also 356.
Thank you very much. Commissioner Bloom just pointed that out.
I thought you were trying to fill every last minute, Madam Hearing Officer.
I am like that, but actually, let me ask. There's no reason not to start public comment early, so we'll do IPA&M's cross-exam after we accept the public comment there is to be given during the session. So let me turn to public comment. We have many opportunities for public comment, 9 o'clock and 4 o'clock every day. Several of them have a Spanish interpreter available. Let's see, let me start with the folks in the room. Is there anyone in the room who would like to offer public comment? Ma'am, if you would come up to the witness seat, please.
Yes, let's clear out stuff.
All right, and just a few things that are applicable to all public commenters. I'll ask you to spell your first and last name, swear or affirm that you will tell the truth, and keep your comments within 3 minutes. If you have more than that to say, please submit it in writing to Sheila Apodaca, the Commission Administrator, and it will be included in the record. So, ma'am, if you would spell your first and last name.
Lori Costello, Lauri. Costello.
Thank you. Do you swear or affirm to tell the truth?
I do.
Thank you. I'll start your time.
I'm a physician currently living in Las Vegas, New Mexico. I am commenting in support of rulemaking to modernize New Mexico's bonding and cleanup rules. While living in Durango, Colorado several years ago, I visited abandoned wells on public land in the heavily fracked area around Grand Junction, where endocrine disruptors had already been found in surface water. I was horrified by what I saw, including stashed behind a bush, an open, white, 5-gallon bucket with a skull and crossbones on the outside. Inside was roughly 3 gallons of black sludge covered with about 4 inches of water, likely rainwater since there was no lid on the bucket. I have long been a supporter of Physicians for Social Responsibility, founded in the early 60s to prevent what we cannot cure. I will include their extensive compendium on natural gas in my written comments. On page 44, it mentions the wildly variable methane leakage from active wells. Then, and I quote, marginal wells near the end of their lifespan, so-called stripper wells, appear to represent a disproportionately large source of methane emissions relative to their production, sometimes leaking more gas than is extracted. Stripper wells are typically not profitable to operate, but because the cost of decommissioning them can be greater than the cost of keeping them running, they remain online or at the ready. Continuing on page 45, inactive wells left behind by industry during energy price downturns or after bankruptcy are growing in number across North America, are poorly monitored, and as conduits for toxic air pollution and fluid leakage are health and safety threats. Some have exploded. As well casings deteriorate, methane gas can mix with gypsum rock to create deadly hydrogen sulfide gas. State and federal policies that do not regulate companies to post bonds covering cleanup costs prior to the start of operations incentivize companies to delay plugging wells as long as possible. End quote. Finally, I am also including in my written comments a link to a recent New Mexico documentary incubator grant production in which I was interviewed. It exposes the harms of oil and gas in New Mexico, including documentation of abandoned toxic wells in both the Permian Basin and the Four Corners area. If they drill it, they must clean it. No more externalization of costs while only profits are internalized. Thank you.
Thank you, Ms. Costello. Is there anyone else in the room here to offer public comment? Sir, if you would come up. If you would please spell your first and last name. Thank you. And do you swear or affirm to tell the truth?
Yes, it is raised now.
Thank you. I'm sorry? Oh, the microphone. Make it green.
Now I got it. Okay.
Terrific. Thank you.
Thank you. So you're the commissioners, I take it,
Yes.
right? Three of you?
Yeah. All right. Go ahead, Mr. Andrews.
Thank you. The wonder is that we are discussing this issue. It's pretty simple. You clean up your own mess. The problem is the mess is expensive to clean up, so the money becomes the issue. There are players in the oil industry who can afford this cleanup. These players have found that if they employ some passive aggression, they can ignore the problem. And one, let the states pay the cost, or two, everybody ignores it. The role of the New Mexico Oil and Conservation Commission is to protect the state of New Mexico. The marketplace can choose who the winners and losers are. You just protect New Mexico from players who don't want to take responsibility for their actions. Let those who can afford to pay the cleanup costs do the work. Our society has evolved to a place where it appears you can choose your own facts and find a tribe willing to confirm and exploit your choice. Nonetheless, you can have your own opinion, but you can't have your own facts. Global warming is a fact. 98% of climate scientists have not failed in their evidence-based and peer-reviewed conclusion. It is human-caused by greenhouse gas emissions, and it threatens nearly every life form on Earth. It threatens the ecological foundation upon which this fantastic array of life forms has blossomed on Earth. It will not allow 8 billion plus humans to consume and pollute at our current rate. Either we live sustainably or most of us don't live. It's that simple. Physics, biology, chemistry are not influenced by propaganda, greed, arrogance, the news media, or AI. They operate according to natural law. We obey these laws or pay the tragic price. Your ambition and fate have put you in a position to play a role in this life or death matter. I ask you to make a choice that you can proudly claim with a clear conscience for generations to come. You have their well-being in your hands. Thank you for listening.
Thank you, Mr. Andrews. Anyone else in the room don't see anyone else I don't recognize. Sheila, would you go to Scott Lewis on the platform, please? Mr. Lewis, can you unmute yourself?
I am unmuted.
Yes, thank you very much. If you would spell your first and last name, please.
Scott, C-O-T-T, Lewis, L-E-W-I-S.
Do you swear or affirm to tell the truth?
I do.
Thank you. Go ahead.
My name is Scott Lewis. I am from Massachusetts, but have lived in New Mexico for more than 40 years. My wife and I are a small business owner, on any given day employing about 10 New Mexicans for the last 22 years. Our business provides good living in the Santa Fe area for all of our staff, as well as our contractor partners numbering near 25. Having access to affordable energy, we have been able to benefit the economy both locally and statewide. The oil and gas industry in New Mexico provides abundant and expensive energy to our citizens, increasing our quality of life, as well as funding about 50% of the state budget. It provides near $100,000 high-paying jobs to New Mexicans. In modern times, access to cheap, plentiful energy has improved the quality of most of the world who have access to fossil fuels. Because of fossil fuels, our world poverty level is about 10% compared to pre-fossil energy times. The New Mexico oil and gas industry is a major supplier in the United States. We are in the top 5 producers of both oil and gas in the country. A major goal of our state government should be to support the industry and keep us competitive nationally. A healthy fossil fuel industry helps provide increased national security. It's my hope that the Commission and state legislature will support our oil and gas industry, continuing to keep our industry competitive, benefiting New Mexicans and U.S. citizens. Thank you.
Thank you, Mr. Lewis. Sheila, I see another hand there. Let's see, Philip Archuleta.
Yes, ma'am.
Oh, yes, hello. If you would, please spell your first and last name.
Okay, it's going to be Philip, P-H-I-L-L-I-P, Archuleta, A-R-C-H-U-L-E-T-A.
Thank you. Do you swear or affirm to tell the truth?
Yes, ma'am.
Go ahead.
Good afternoon, everybody. My name is Philip Archuleta. I am a born and raised New Mexican with a background in oil field and gas safety. I am also a Navy veteran. For me, while serving every day was a day for safety, not only for our country, but also for the environment. My job as a sonar technician required us to ensure that before any exercise, safety of the environment was a top priority. A decade later, I found myself working throughout the Permian Basin as a safety technician. The stringent requirements of both fields felt oddly familiar and made for a smooth transition between the two. The environmental safety and OSHA regulations created an environment that made job site hazards more manageable. Though I'm no longer in the oil field, I continue to see these benefits from oil and gas, especially in New Mexico's annual budget. Some current examples would include hard skill classes at the local colleges, supplementing universal child care for all New Mexicans, and to me, the most important, the Opportunity Scholarship. As a college student, I'm seeing these benefits firsthand amongst myself and others that I'm going to class with. Continued support for the oil and gas will help to grow these programs and others long term. Along with that, I hope it'll give other veterans and New Mexicans the opportunity to provide for their families and provide a reliable tomorrow. In closing, I am asking this commission to protect the livelihood of New Mexicans, especially those working in the oil and gas industries. Thank you.
Thank you, Mr. Archuleta. Is there anyone else on the platform who would like to offer public comment during this session? We'll have our next session at 9 o'clock tomorrow morning. If you're on the platform, please raise your virtual hand, or if you're on the telephone, please press *5. I don't see anything else, Sheila, do you?
No, I don't see anything.
All right, at this time then, we will go back to the technical case. Bring Mr. Peltz back.
And Sheila, if Ms. Tripp could get screen sharing authority, please.
Yes, once more to Ms. Tripp.
And Ms. Tripp will start off with Exhibit 65, I think, in the slideshow.
Okay.
Just a second.
Oh, I'm sorry, Mr. Cloutier. It appears Senator Gallegos is on the platform and would like to offer comment.
I will yield to Senator Gallegos.
Thank you very much. Senator Gallegos, would you unmute yourself, please?
Did that do that?
Yes, I can
Madam-
hear you.
Madam-
So,
Go ahead.
yes, so Senator David Gallegos, that's David, Gallegos is Gallegos.
Yes, ma'am.
Do you swear or affirm to tell the truth?
Yes, ma'am, I do.
Oh, please go ahead.
Thank you, Madam Examiner. Thank you for allowing me to speak, and I apologize being late. I was trying to get on the computer. But I am Senator David Gallegos from District 41 in the heart of the Permian Basin. And I'd like to speak tonight about the respect of the legislative process. For approximately 7 years now, if a bill does not make it all the way through the legislature and it dies, then it seems to be made into a rule. I would just like to visit with y'all because our state has a legislature for a reason, and it's to provide the New Mexicans to have a voice. And where the rule process, just a few bureaucrats sitting in a room deciding for everyone, I don't feel that's fair to the Mexicans to depend on small independent producers to do their jobs, who in fact will then follow up providing funds for our individuals, which are teachers and students across the state. But Madam Examiner, being in the minority, I feel my voice is already hard to hear just due to sheer numbers in Santa Fe. But when the majority in Santa Fe failed to pass a bill, that shows that New Mexico does not need or want that issue to go forward. And we speak for our constituents. For instance, the bills that failed and now have us here to this point of this rule hearing are as follows. In 2014, we had House Bill 133, which is Oil and Gas Act, and it had 2 hearings and then died in the House. In 2025, House Bill 257, the Oil and Gas Transfer Rulemaking, it didn't even receive a hearing in the House. In 2025, House Bill 258 was natural gas capture regulations. It did have 2 hearings in the House, but never advanced. And finally, in same 2025, House Bill 259, Oil and Gas Act violation penalties, had 2 hearings in the House, but never advanced either. So that's 4 bills with the majority sponsors that never left the first chamber. And I would bet in the next session, these bills will be back. And I would ask you that you would consider the process and letting the process work and letting the Mexicans have voice in the decision, not use the rule hearing as a method to enact these bills that failed in the last 2 regular legislative sessions. I do believe they'll be back. I do believe we'll have hearings on them. And I do ask that you just consider this for all those that depend on our decisions tonight, our educators and the students in our state. I would just ask that you would just consider these as you make your decision going forward. And I do thank you for your time.
Thank you very much, Senator.
Thank you.
All right, let's restore screen sharing to Ms. Tripp.
Should be seeing Exhibit 65.
Sorry about that. It's the one that shows the Wolf Camp, Bone Spring, Sprayberry production, and may have been earlier than that. Scroll up. Keep going. That's the one right there, and the pink and red there in that 3 slide. The EI EIA figures slide? Thank you. Okay. Good afternoon again, Mr. Peltz.
Good afternoon.
Wanted to pull up these EIA figures that I denominated, but I wrote down while you were testifying about this is one of the things that you commented was when we were looking at these slides was that there'd never been a better time for industry to address the orphan well issue and the potential for future orphan wells.
Yes, make hay while the sun shines.
Right. So the Colorado example you gave was an interesting one where each operator contributes per well to a fund, correct?
Yes.
Right. And that's not this rulemaking.
Correct.
And for instance, we don't have the Sprayberry Formation in New Mexico, but an operator who is developing these prolific Wolfcamp and Bone Spring wells in southeast New Mexico, those wells are not marginal wells. They may have marginal wells in their portfolio, but those are not marginal wells, correct?
Not by any stretch of the imagination. They're some of the greatest wells in history.
They are indeed. Yes, I fully agree with you.
For now, at least.
Yes, no, I mean, that's the nature of wells. And one thing certainly we agree on is wells decline over time. There are ways to increase production, but ultimately they decline, correct?
Correct. And shale wells decline faster than conventional wells.
That's what I've noticed too. But the hay that these operators are making is not particularly helpful to, say, one of my members who may be an operator of Fruitland, Pictured Cliffs, and Mesa Verde gas wells in the San Juan Basin, is it?
It's not a perfect one-to-one match, unfortunately.
Right. And so the hay is not being distributed evenly to those that are going to be most affected by this bonding.
It rarely is.
Right. I just want to make that clear.
Yeah.
I agree with you. Okay, we covered Exhibit 7, but I'd like to pull up the, was that the one with the Arkansas?
Although, is it too late to add a thought?
I will not object to you to add a thought, Mr. Peltz.
So, one other thing that's happening is this projection of price decline, and that happens for everyone. And so, that is definitely a factor in why you'd want to do it while the prices are relatively high.
I understand, but if the increased production isn't affecting one of the affected people, it makes a difference, doesn't it?
It sure does.
Yep. Okay, we looked at this policy reform across states, and I'm in particular interested about the Arkansas experience. First of all, and I appreciate you said so, and you say so in this slide, the close to full cost financial assurance that you're describing only occurs when the well is transferred in Arkansas, correct?
Correct.
All right. And do you recall what the amounts of those bonds were?
$30,000, and it's gas well only.
Right. And
Excuse me real quick. Mr. Peltz, if you'd be reserve your answer until Mr. Cloutier is done with his question, it will just help the court reporter.
Yes, indeed. I'm sorry I got excited.
I understand. It was like buzzing in for a Jeopardy answer or something, right? So, no, I speak a little more slowly than you, Mr. Peltz, so I apologize if that causes you any inconvenience, but approximately $30,000 for gas well only, correct?
Yes, sir.
All right, thank you.
Although that was 7 years ago.
I understand, but
yeah, and Arkansas is a different story than New Mexico.
I agree. Exhibit 84, please. All right. So there's a lot going on in this exhibit, but as I understand it, the sixth column from the left, total estimated 2024 revenue. That is your estimate of when you're comparing operator revenue. Is that your estimate of operator revenue?
Well, that's a gross revenue figure, which I believe is production times commodity price.
That's the first question I was going to ask. Thank you. Do you know what the revenue to the operator is?
I don't.
Okay. And do you know that operators do not own 100% of the revenues from the well stream?
I do.
For instance, there's royalty interests that are non-cost bearing interests that get a percentage or fractional share of the revenue stream, correct?
Yes. If I could ask you what percentage it actually is, I would, but I can't.
The older leases go as low as 1/8, and current leases generally around 25%.
Okay, fair enough.
There, I answered a question for you, okay? And there can also be overriding royalty interests, which are carved out of the lease and are not cost bearing, correct?
Correct.
And everyone except the federal government is a royalty owner, and the state government here in New Mexico is a royalty owner, pays severance taxes on their production revenue right off the top, correct?
Yes, and I think there's a few different fees in New Mexico.
Right. There are 4 different forms of severance taxation. Depends on which local governmental entity, because one of them, local governmental entities can vary the percentage a little bit, but roughly 9% gas, roughly 8.15% oil. You're nodding your head?
Well, I believe you.
Okay. All right. Do you know what the term contract operator means?
I don't.
Okay. Are you aware that there are operators in the oil and gas business who own no interest in an oil well that they operate?
And would they just get paid for service or something like that? I wonder.
That's the contract, yes.
Well, if you say so, I believe you.
Okay. You indicated some familiarity with Mr. Ezel's testimony.
The parts that I responded to.
Okay. Did you read his testimony about the contracts that govern operations in the oil and gas industry commonly?
I didn't.
Okay. Do you disagree with his conclusion that an operator under most of those forms of contract probably doesn't have any chance of raising single bond cost from the other owners in the well?
Well, because I didn't read it thoroughly, I can't really opine on his conclusion.
Okay, I'm just making sure you don't disagree with that. So,
well, I neither agree nor disagree. I would need to do
all I asked if you disagreed, so I'm not asking you to agree.
Do I disagree? I'm not sure.
Okay. You're not going to offer an opinion to the commission one way or another.
I would want to read it first and think about it.
Okay. But this is your day in the sun to testify, correct?
Yes, it's ironic.
All right. All right. There we go. Yeah, let's look back at the Exhibit 84 again, please, Ms. Tripp. Ms. Tripp, there we go.
Yeah, you should be seeing it
Sorry.
now.
Yes. So I want to ask you a question about this last column. Actually, this table was in your rebuttal testimony, correct? Exhibit 84?
Yes.
Could we get a page 13 of Mr. Peltz's rebuttal testimony? And while we're doing that, the last column, 1% of total bonding liability, how was that calculated?
So that was, taking what we projected to be the bonding liability for each operator, and taking 1% of that on grounds that might be a premium. there could be more columns here showing higher percentages, but there aren't.
Okay.
And then taking that as a percentage of the gross revenue. I would say that it's illustrative rather than telling you exactly what it is. And certainly based on what you said about the reductions of gross revenue, the numbers would be different. But what's interesting to me about this is how different the figures are for the above 15% portfolio and the below 15% portfolio. I suspect that those ratios would be similar, even if you had better figures on what net revenue was, for example.
Okay. And you did answer a couple of my questions, and that answer to what wasn't a question, but thank you. The footnote 3 indicates that what you were using was a offshore study of sureties, correct?
Yes.
All right. And those are what, $2 million per well bonds that are required by the federal government for offshore?
Yes, unfortunately, it's hard to get such figures for onshore.
Okay. Mr. Peltz, thank you. Those are my questions.
Thank you.
Thank you very much, Mr. Cloutier. Mr. Sayer, do you have questions of Mr. Peltz? Thank you. Mr. Rankin, do you have questions of Mr. Peltz?
Yes, I do. Afternoon, Mr. Peltz. How are you?
Good afternoon.
I understand that you engaged in the legislative process in New Mexico in the 2024 legislative session, correct?
I did.
And I think I caught you saying that you were the co-lead on the committee addressing the plugging and bonding issue. Is that right?
Yes.
And as that in that position, what was your role? What did you do on that committee?
So I convened calls with all stakeholders, industry, ENGOs, and OCD to start exploring these issues. And one of the things that we tried to come up with was a series of principles about how you might approach financial assurance. And we got fairly far down that road.
And what was the direction that the road was taking you?
Well, I think the core thing was that financial assurance should be risk-based.
And how was that panning out? I mean, what was the structure of the risk-based approach?
What we realized was that with the time allotted, we were not going to be able to come up with a perfect decision. And so eventually what the deputy secretary of MNER, Dylan Fuge at the time, said was, well, what we should do is we should increase the blanket bond maximum and then do the rest through rulemaking because it's way too complicated to do in legislation. All the details.
Okay. So what I understand you say is that for the 2024 session, given the time frame you had, you weren't going to be able to accomplish what the committee was setting out to do, right?
No, but I really appreciated the opportunity to talk the issues out with industry.
So just needed a little more time potentially to get some of those issues worked out legislatively. Agree?
Well, maybe a lot more time, but more time for sure.
Okay. So the 2024 session wasn't adequate, but
it was the run up to the 2024 session. We started, I want to say, in September, but a decision was needed for what to go with by maybe it was sometime in December, and we were not meeting very frequently. Okay. Unfortunately, because there were a lot of issues at play in the Oil and Gas Act at that time.
Right. So in other words, for purposes of the 2024 legislation, there wasn't enough time, right?
Correct.
But there are future sessions, correct?
Well, there's always going to be a session.
Right. So have you been involved currently with any legislative efforts to make any changes?
No.
No. Why not?
No one asked me.
Okay. Did anyone ask you the first time around?
Yes.
Okay. And who asked you that time?
It might have been Dylan.
Okay.
But actually, I can't remember for sure.
But the point being that you haven't been asked, and so the EDF has not made any concerted effort, any effort currently to make any changes legislatively in New Mexico.
Correct.
Okay. So in that 2024 session, the direction shifted to updating or amending the blanket bond, correct?
Correct.
And what was the proposal to amend the blanket bond in that session?
The original proposal was to increase the maximum blanket bond to $10 million.
Okay. But that, it didn't ultimately pass, correct?
No, well, it was modified on request of industry to a schedule where $10 million was the maximum, but it was based on operator size, not based on risk. And I believe that everyone said, okay, fine. Namoga went to neutral and it kept moving in committee and it made it through 3 committees and then someone was out sick or something like that.
Sounds complicated.
It was. There were a lot of weekend phone calls.
But the bottom line there, I suppose, is that there was some agreement about a blanket bond, but it didn't, time ran out effectively, correct?
Effectively, yeah.
Okay. So now the failure to pass that bill, is that what prompted the genesis of this rulemaking here today?
I don't know if there was a direct lineation. I think the idea was we have to deal with this orphan well issue. And that's what led to this rulemaking.
So the failure to address it in the legislature necessitated, in your mind, the need to go to rulemaking?
There was going to have to be rulemakings anyway. This has to be dealt with by rule. It's too complicated to deal with legislatively.
In other words, even if the legislature provided some guidance, there would need to be rules promulgated to implement those.
Oh, yeah.
changes.
A $10 million cap is just the start. Then you have to figure out under what circumstances, how do you do the risk basing? There's no risk base in having a $10 million blanket bond. It just, would give some room for rules to happen underneath that.
Okay. So other than that legislative engagement, have you been involved in any other legislative or regulatory efforts in New Mexico to address financial assurance on oil and gas activities?
Well, this rulemaking.
Right. So this rulemaking and then that legislative effort from the previous session, correct?
Yes, I was also watching, I can't remember the name, it was HB 316 maybe, for the beneficial use of end-of-life wells outside of oil and gas purposes. So the gravity storage, that sort of thing. And I believe that was in the last legislative session. And I watched that, but I didn't really participate. Although I am a fan of beneficial use of end-of-life wells.
Other than this rulemaking before the commission, have you ever been involved in any other prior rulemakings before the OCC?
I have not.
Okay. And other than, let's see, now, I understand that you are a lawyer, right?
I am.
But your direct written testimony and rebuttal did not provide express interpretations of New Mexico law, right?
Yeah, as I said, I'm more of a subject matter expert and, working with the analysts to try to understand what the data tell us.
Okay. So yeah, you're not here testifying as an expert in New Mexico law, right?
Not particularly.
Okay. Or not particularly or not at all?
I've been asked a few of those questions and I've opined. So I guess to that extent, yes, but.
Well, let me rephrase it this way. Are you holding yourself out as an expert in New Mexico law?
No.
Okay. I think Mr. Suazo asked you many of the questions I was going to ask you about your background experience. But just to be clear, you're not an expert in public or environmental health, correct?
No, although I know a lot of them.
Right. But that's not your expertise, right?
No.
And you're not an expert in toxicology or the impacts of oil and gas on the public health, right?
No, although I've read a bunch of studies.
Got it. And so you're not holding yourself out as an expert in either of those areas, are you?
No, I'm a conduit from those experts to you.
Now,
If you want to hear a story about public health and abandoned wells, I'm happy to tell you one.
Sure, there's all kinds of stories. No, I don't think so. But maybe over a beer after the rulemaking. Let me go on. I'm going to ask you some questions about your testimony that were elicited today. And I was curious about the, your discussion around Utah and the rulemaking that's going on in Utah.
Yes.
And you've been involved in that rulemaking, right?
Yes, for 3 years.
3 years. Why is it taking so long in
I
Utah?
don't know. It's been in an informal discussion phase that that the agency there, they go by DOGM, Division of Oil, Gas, and Minerals, I guess. They've been hosting informal stakeholder discussions with the Utah Petroleum Association and EDF for 3 years, and we've done 9 rounds of comments on this informal draft. It is thorough, if a little infuriating.
Yeah, well, it's, rulemaking, I guess, sometimes, huh?
Every state has its own funny way of doing it.
Yeah. Now, I'm interested in this because I think in your testimony, you not only refer to it in your opening where you discussed it as the approach in Utah was to set up the blanket bond as a privilege, right? Not as a right. That was the approach in Utah, correct?
Yes, that was their core idea.
Okay. That's because in Utah, there's not a statute that mandates a blanket bond, right?
Nor is there one here. It mandates it as a possible category, but it doesn't, mandate that everyone have it necessarily.
Okay. All right. So well, I'm going to hold that and may come back to that opinion of yours in a moment. But as to Utah, there is no statutory provision in Utah mandating a statewide blanket bond of any kind, right?
No, if there is, the Utah Petroleum Association hasn't brought it up.
But you haven't, you've been involved for 3 years, but you haven't reviewed the statutes in Utah to determine whether it does or doesn't?
They appear to allow the agency to do whatever it wants.
Okay. Well, just so we're on the same page, I'm going to pull up the statute in Utah that addresses the bonding, and it's referenced in the rulemaking in Utah. Okay, I'm going to just go to the top of it. This is 40-6-5, the jurisdiction and board rules. And when I scroll down to the bottom of it here, it identifies, specifically provides that the board shall review rules made under subsection 2F to determine whether the rules provide adequate fiscal security for the fiscal risks to the state related to oil and gas operations. And it goes on to say, during the board's review under the subsection, the board may consider the bonding schemes of other states. I'm just summarizing that, but nowhere in the rules or statutes that I could find does it provide for bonding statewide bonds. And based on your experience, that's your understanding as well, right?
Yes.
Okay. And so Utah then has the freedom to make bonding a privilege, right? In the rulemaking, right? Okay. Now, in your direct testimony at the bottom of page 49, I've highlighted some language here where you discuss the approach was taken in this rulemaking, as I understand it. Okay. It says paragraph 3 is patterned after a rule proposed by Utah's Division of Oil and Gas and Mining, which requires single well financial assurance for all of an operator's wells if more than 25% of the well population is idle or below 1 barrel of oil equivalent per day, and reserves the lowest cost tier of blanket bonding for operators with less than 15% idle or below 1 barrel of oil equivalent per day. And that goes on with an additional minimum total production criterion for all the operators' wells in the state. I read that.
Yeah.
I got it. Okay. So I guess my question to you is, how is it in your mind patterned after the Utah proposed rule?
Well, the concept of being able to proxy risk by production and by percentage of portfolio with high risk wells is the way in which it's patterned.
Okay, would you mind I was trying to follow along there. Just mind restating that for me? Just so I make
Sure.
sure I-
So the two elements of what what Dogum is planning on looking at in Utah is fleet production and then their percentage of wells that they consider to be at risk. In fact, they call it at-risk wells. And at-risk wells, as Dogum proposes to define them, are inactive wells and wells producing less than 1 BOE per day.
So the way that concept is being carried over in this proposal is that language in the rule, and I can pull it up, but basically every operator that has a portfolio that exceeds 15% marginal or inactive wells thereby then has to pay this additional bonding of $150,000 per well and no longer is able to seek the financial assurance under the statewide blanket bond, right?
Yes, because they're in a new category that the agency can create of, portfolio risk operators. Although it's not labeled that way, but that's basically what it is.
Yeah, so they're creating a new category and then they're also precluding the use of that statewide bond for the portion of those wells that remain active, producing wells above the marginal definition, right?
Well, that category, once you create it, covers all of those operators' wells.
So even though there's two different types of wells in that category, right? One category is the category you're creating, which is the marginal well.
Yeah, it's an operator category rather than a well category.
Okay, let me just finish my question.
Sorry.
Okay, that's all right. So the two different types of wells that we're talking about here. One is the new category well that you're creating, which is the marginal well category, right? As defined under the proposed rule. And the one well financial assurance that is being proposed under this rule would apply to that category of wells, right?
Yes.
And then for operators with a portfolio in excess of 15% marginal and or inactive wells, that additional bonding is applicable to the remaining wells in their portfolio, right?
Yes, as an operator category.
As an operator category, okay. So the effect of that is that you've got two different types of wells in financial assurance in that, rather two types of wells in that grouping, some of which meet the new category of marginal well and some of which don't, correct?
Well, there are two different there's the category of marginal wells, and then there's the category of operators that have too many marginal wells.
So your view is that the statute allows for the division to create all kinds of categories, whether it's a well category, operator category, what have you. Is that right?
Yes, that's what that first sentence in your rainbow slide has.
Okay. So it's not clear to me in the rule that it says anything about operator categories.
Well, that's, implicit in how it's set up.
Okay. So under that approach, then the division could make new categories based on operators and can target different types of operators with different characteristics, not just based on their wells, correct?
If the commission votes for it.
Okay. So that's interesting. Okay. So and that Utah rule is still not final, right? It's still under consideration, right?
No, they're having a hearing on December 3rd, and their intention is to go to a formal rulemaking from there with notice and comment.
Okay. And that rule basically requires operators to meet certain qualifications in order for them to qualify for a statewide performance or blanket bond, right?
Something like that, yeah.
Okay.
What I find really innovative about their approach with those low producing wells is in fact to incentivize operators to either increase production or plug them.
I want to talk about that. That's my next line of questions. Okay. So as I understand the language that we're talking about here, okay, and I can pull it up just so I'm trying to think who has the best. I think actually maybe Mr. Purvis had a pretty good. Mr. Purvis's PowerPoint, I think, had a pretty good slide that had all the language in it. Okay.
I love his PowerPoint. So many good slides.
All right. So the paragraph we're talking about here is this subparagraph 3, right? That's the one that is modeled after the Utah approach so far, right?
Yeah, conceptually.
Conceptually. And so the way this is set up, as I understand it, and the incentive, right, that's being created is that under the proposal that we're looking at here that applicants have in front of the commission is that it ties financial assurance for active producing wells, right, that are above the marginal definition, okay, to the one well financial assurance requirement for this new marginal well category, right? So that when operators' well portfolios exceed the 15% marginal well proportion, they're required to pay that $150,000 bond on all their wells, right?
Right.
So what it does is it ties that financial assurance for the non-marginal wells to the marginal wells. So as they reduce their proportion of marginal wells, they can come out of that category, right?
Yes.
Okay. And that's the incentive that this rule's intending to set up, right?
Yes.
Okay. Okay.
As
So-
well as to protect the state from systemic risk.
But at the same time, right, when they're in that category, when they're in that new operator category, when they've exceeded the 15% marginal well and or inactive well proportion, they're no longer able to rely on the blanket bond, right?
Right, because they're in a new and different category.
Okay. So isn't that making the $250,000 statewide blanket bond into a privilege by qualifying for it rather than a statutory right as provided under the statute?
Is it a statutory right? Oh, I can't ask you questions. I'm not sure if it's a statutory right exactly that every operator be able to access that category that's created by the legislature. But again, I'm not an expert in New Mexico law. That's just my opinion.
Okay. So when I look at the statute and the green, everyone's favorite rainbow, okay. Mr. Cloutier was criticizing me for not having the sequence right, I think, but under the green here, right, where it says that such category shall include a blanket plugging financial assurance, which shall be set by rule an amount not to exceed $250,000. My understanding is your view is that even though the statute says that it's there and it says that it should be required, shall be required, that it's not necessarily the legislature's intent to make that available for operators.
It's not clear to me that every operator can get every conceivable category.
Explain that.
Well, there's a bunch of different categories in here. I'm not sure if the operators can always elect it or if they can be told by OCD which ones they're supposed to use, but it's an interesting question.
Okay. So I guess what I'm hearing you say is you think that there's some ambiguity in the potential interpretation of that statute, huh?
As with most statutes.
And if there's ambiguity, do you think it would be helpful for the legislature to provide guidance on what it means or what they mean?
Well, I think the agency can interpret the statute. I mean, that happens all the time everywhere.
Yeah, I guess if that's part of their expertise, I suppose that may be something they can do. All right. Well, I guess I'll leave that there. But I think this discussion was helpful because it allowed me to understand a little bit better because I didn't understand that there were such things as operator categories. Okay, so that was helpful for me. Or at least that was a concept and implicit in this rule. But generally then, just kind of wrapping up our discussion around the statute, you agree with me that state agencies are constrained by the applicable law, the organic law, right? Whatever it is, whatever it may be, right?
Yes.
They'd be constrained by the limits imposed by the legislature.
Yes.
However, the legislature or the courts may interpret it, right?
Yes.
Or the agency itself interprets the limit of their authorities, right?
Yes.
Okay. All right. before I forget about it, I do want to touch on a couple things, and I have a few other topics I want to touch on as well. But before I forget about this, on the temporary abandonment status wells,
Yes,
you were present for the testimony of Mr. Alexander,
I was.
and you recall that he testified in questioning to myself and then also to Dr. Ampoma, Commissioner Ampoma, that there would be likely exceptions to the utility of having wells stay in TA, limited to only 8 years, right? That
Yeah.
there may be circumstances that would justify allowing wells to go beyond the 8-year period for TA as proposed under this rule, right?
Yes.
And Mr. Alexander gave us some potential factors or categories of information that he could foresee being useful for the division to consider in evaluating whether or not a well should be allowed to go into additional periods of temporary abandonment status. Do you recall that testimony?
Yes, I thought they were thoughtful ideas.
Okay. And I'm going to try to summarize them, but he talked about, wanting to know what the scope of the proposed use would be, timeframe, a definite timeframe for how long the additional temporary abandonment status would be, periodic review by the division to confirm that the additional status and TA status was appropriate. And then I think sound engineering and technical information, not just guesswork, right? Those were, I think, the 4 things that he talked about. Do you agree?
Something like that.
Okay. And would you agree with Mr. Alexander that there are exceptions that may justify having, based on those factors, allowing the division to have additional discretion to extend wells into additional temporary abandonment status periods?
Yes, in a limited and tailored way that does not swallow the rule or the intent.
Okay. And rather than having an indefinite, period or multiple periods, if that were to be provided for, like, say, another 5 years, discrete periods of time, would that be, do you think that would be a reasonable approach?
Well, I'm not sure about a default number of extra years. I mean, if you're going to go through that process of doing those steps, in that process, you can probably articulate around how many years is my guess, not positive.
So that would be something that the applicant for the additional time frame in the division, based on whatever they're asking for, they would justify it. Is that what you're suggesting?
Yes,
Okay.
something like that.
But I just want to be clear that your testimony today, it doesn't foreclose. You would agree with Mr. Alexander that there are exceptions, and with the right information, the division and the applicant should be allowed to approve additional temporary abandonment status periods.
Yeah, like if you in particular are planning a big CO2 EOR project and it's going to go on for this many years and involve this many acres, and you're waiting to turn these wells on to be injectors and that sort of thing, and you can lay all that out, well, I would think that the agency would be happy to hear that.
Preventing waste, right?
Yeah, CO2 EOR, the
Yeah.
way to go.
But you wouldn't limit it to that, right? I mean, that scope. I mean, it could be other potential uses if it could be justified,
I
right?
could imagine that seems to be the best example.
Oh, I do. Okay. Oh. Well, we're at 6 minutes before the hour, and I think I'm going to wrap it up. Mr. Peltz, I appreciate your time and your engagement and answering my questions. I don't think I have any further questions of you at this moment. Thank you very much.
Thank you.
Thank you, Mr. Rankin. Mr. Maxwell, do you have any questions?
Your Honor, I have no questions. Thank you.
Thank you. Ms. Nanasi? No. Mr. Moore?
No questions, Madam Hearing Officer.
All right, thank you. Mr. Tremaine, will you have questions? I'm not suggesting you do them now.
Surprisingly, no. No
All
question.
right, thank you. So if the redirect would be very short, Mr. Tisdale, we could do it now. Otherwise, we can pick up in the morning.
I think we could probably run through redirect pretty quickly.
All right, go ahead.
Just a few points of clarification. You recall the questions you received just relative to the timing of the legislation, HB 133, and the rulemaking process that we're engaged in?
Yes.
Do you recall from the testimony of Mr. Alexander that he began engagement with applicants in the summer of 23 on this rulemaking?
Yes.
And did that precede your engagement in the stakeholder process with HB 133 that OCD initiated?
Yes, that was more like September 23.
So is it safe to say that the rulemaking is not an outgrowth of the parallel legislative process that was taking place then or even now?
I think you make a good point.
Okay. I want to also talk a little bit about the Utah rulemaking that has been going on for quite some time.
Yes.
Yeah. And that is a broad stakeholder process that includes industry representatives and trade associations in Utah.
Yes.
And what is the current threshold for blanket bonding for marginal wells that is the current place that the stakeholders there are talking about?
Do you mean in terms of like BOE production or the percentage of how many in the portfolio, or
the availability of the blanket bonds? Is that Utah process similarly tied to a threshold of their marginal wells?
Yes, if an operator has too many at-risk wells, Utah does not want to give them a blanket bond.
Yeah. And that threshold is currently agreed to by the stakeholders, including industry in Utah?
Well, it's still in flux.
Okay.
But the fact that there should be a threshold is in agreement, it seems to me.
Okay, thank you. And I don't want to belabor the point on the colorful graphic that we've been referring to with the statutory provision in 72-14. But I do want to talk a little bit about the categories within it. We don't need to bring it up. But there's two categories that have come up quite a bit, which is one is the category that is created that a category of blanket bonding that shall not exceed $250,000, correct?
Yes.
There's another category for blanket bonds for temporary abandonment wells that sets a floor of $50,000. Is that correct?
Yes.
Could an operator, could both of those blanket bonds be applied to an operator in a way that makes them non-exclusive?
Yes, and I'm sure a lot of operators have both.
Okay. Thank you. No further questions.
All right, thank you very much, Mr. Tisdale and Mr. Peltz. We'll begin in the morning with public comment and then turn to commission questions of you.
Great, thank you.
All. Good night.